Thank you very much. Can we note apologies, Koliswa?
Good morning, Chairperson. And good morning to members and the guests. I didn't receive any apology, Chairperson, for the meeting today. Thank you.
Thank you very much. Can I then get somebody to move for the honorable members to move for the adoption of the agenda?
I move the adoption, Chair.
Honorable Sifai moved, and can we get seconder?
I second, Chair Malachi.
Okay, thank you very much. The fourth item on the agenda is consideration and adoption of the motion of desirability for the Housing Consumer Protection Bill by the committee. I'm going to allow Sabelo to take us through. We have the legal team of Parliament. I think so, Koliso. Are they here?
Yes, Chairperson. The legal person from Parliament and also the state law advisor.
Yeah, and the state law advisor. They will be with us. Members are welcome to engage this bill. Today we have the legal minds that would help us to go through the agenda. I should mention, honorable members, that I've got load shedding. If my network disappoints me, I'm going to request that you forgive me, and maybe we can then agree that without adjourning the meeting, Honorable Malachi, if I have a problem of network, assisting in the process of directing the meeting. Do we agree, honorable members? Honorable members?
Hello, Chairperson. You said you are suggesting who to take over the meeting when you experience a problem of load shedding.
Honorable Malachi.
I second it.
Okay, thank you very much. So, Sabelo, can you then take us through both the number 4 and number 5, and then members would then deliberate on.
Morning, Chairperson. I'm uploading the bill.
Start with the motion, Sabelo.
No, it's fine. The background is gonna cover it. Can you see the? Okay. Morning, honorable members and Chairperson. So I'm gonna read the motion, and it's gonna cover the background of the bill. So the intention of the bill is to provide the protection.
Recording in progress.
Is to provide the protection of housing consumers, provide for the continuation of the National Home Builders Registration Council as a National Home Building Regulatory Council, provide for the registration of home builders, provide for the enrollment of homes in order to be covered by home warranty fund, provide for claims against the fund, provide for procurement and contractual matters in relation to building homes, and provide for enforcement of this act, and provide for the repeal of the Housing Consumer Protection Measures Act of 1998, and provide for matters connected therein. With regards to the bill, it's covered in Chapter 1, and Chapter 1 deals with interpretations, the definition, the application of the Act, application of the Public Finance Management Act. Chapter 2 deals with National Home Builders Regulatory Council, and this is it covers the objectives of the council, the composition of the and vacation and removal from office, the fiduciary duties and disclosure, the remuneration of members, and the meetings of the board. And so basically it deals with the functioning of the board. Chapter 2 deals with the registration of home builders. Covers the register of home builders and developers, content of register, home builder or developer to be registered, and requirements for registration. It also deals with the cancellation and suspension of developers, and also the liabilities of unregistered home builders. Chapter 4 deals with the enrollments, and this basically deals with the enrollments of homes and and the consequences in relation to failures, and MMCs or social housing institutions or delivery agent to comply with the Act. And then Chapter 5 deals with the financial, the warranty fund and additional funds, and the issues of the bank accounts, the management of the funds, and also the establishment of non-profit and the fees that are related to the bill. Chapter 6 deals. No, Chairperson, that is fine. That is the that is Chapter 6, and then Chapter 7 deals with the systems of enforcement of the Act, the compliance and enforcement of committee, powers and duties and compliance and enforcement of the committee, and also it deals with the administrative issues and the issues of non-compliance with the Act. Chapter 8 deals with issues of miscellaneous issues. It covers the issues of the code of conduct, the issue of savings, the issue of the rules that are applicable, and the duties of conveyancers, and the issues of short title and commencement. And then that's the last chapter, Chairperson. Thank you.
Sabel, were you not supposed to start with the, where is the motion?
As far as I understand, Chairperson, the motion for desirability is basically the purpose of the bill, Chair.
Hello, Chairperson.
Yes, Koliswa.
The motion of desirability, Chairperson, I drafted it and then forwarded it to you. And also I just forwarded to all the members now. We are supposed to read the motion first so that we agree, as the committee agrees on it, then we go to the bill. So I suggest that Sabelo forwarded you the motion as well. If he can start with the motion so that we can start there before we go to the bill. Thank you, Chairperson.
I don't have it, Collins.
Check the email.
Can
you
you
flag-
put it up so I can?
Can you flag it, Koliswa?
Okay, Chair, stop sharing, Sabelo.
Okay, the motion of desirability of the Housing Consumer Protection Bill, the Portfolio Committee on Human Settlements for consideration and reporting in compliance with National Assembly Rules 9 Edition Rule 286. The rules read as follows. Please go down, Koliswa. If a bill has been published for public comment in terms of Rule 276 or 295, the Assembly Committee to which the bill is referred must give interested persons and institutions an opportunity to comment on the bill. If a bill has not been published for public comment and the committee to which the bill is referred considers public comment on the bill to be necessary, it may, by way of invitation, press statement, advertisement, or in any other manner, invite the public to comment on the bill. Rule 286 further reads as follows. The committee, after due deliberation, must consider a motion of desirability on the subject matter of the bill, and if rejected, must immediately table the bill and its report on the bill. If the motion of desirability is adopted, must proceed to deliberate on the details of the legislation. Thank you, Chair.
Can I get members to comment on the motion? Honorable Seflai, I see you have,
Chairperson,
yes, Honorable Tseki. I've noted Honorable, oh yes, remove the hands. Can I see the hands, honorable members?
discussing with the process, not the content necessarily.
Yes.
It gives two options. The first one is whether the bill is desirable for it to continue, which is option 2. One wants to support that it's desirable for us to continue. And therefore my assumption is that in the debate, we will deal with substance of why it should continue. I hope I'm correct. Thank you, Chair.
Thank you, Honorable Tseki. Can I get any other member? to
Yes,
talk
Chair. I've been
to-
struggling to. I'm using a new gadget here. I don't
Mm,
know what's wrong. I've been struggling to raise my hands with it.
Okay,
But I want to say that because there's a platform to whether I agree or disagree with the motion, I want to agree with the motion.
okay, thank you, Ms. Hart. The motion has been seconded. Any other member who wants to, do you have any member who wants to differ with the motion? Which you are saying that the bill is we should adopt the motion and proceed with the reading of the bill. I don't see any other hands, means that all of us were agreeing.
Mr. Heron, Chairperson.
Or yes, I don't know, I don't see your hands, Honorable Haran. Oh yes, Honorable Haran.
Thank you, Chairperson. I just want to check that I understand what we're agreeing to. We're agreeing that the bill is desirable and should proceed, but we're still going to get into some of the content where we may disagree with some of the clauses. Do I understand that correctly?
Yes, yes.
Okay,
That's
then I
where we
support
are
that.
now.
Thank you. Thank you.
Thank you. Thank you very much. Any other member? I don't see any other hands, means that we agree. We'll then go to the formal stage of dealing with the bill. Maybe let me give the legal person from the parliament. If there is anything that you want to guide, you're welcome.
Good morning, Chairperson, and happy birthday. Good morning to all on the platform. At this stage, Chair, there's nothing that I want to add. It's literally just the process of the committee going through the clauses, clause by clause. And as we do that, if anything comes up regarding to legality, we will come in. But we are here, Chairperson. Thank you.
Thank you very much. Sabelo.
Yes, Chair.
Let's start with the four. Who's that? Honorable.
It's me, Chair.
Okay, proceed, Sabelo.
Okay, Chair, I'm going to start with chapter 1, interpretations. Number 1 is definitions. In this act, unless the content indicates otherwise, build in relation to the structural integrity of a home means establishment, installation, repairs, renovation, alteration, or extension of a home, and construction and construct have the same meaning. Certification body means a legal person approved by council to provide certification service in respect of the design or compliance with home building manual through its certifier. Certifier means employee or agent of certification body appointed by the home builder to issue certification in relation to a design or compliance with the home building manual. Build, but excludes an inspection appointed, but excludes an inspector appointed in terms of section 70. Chief Executive Officer means the Chief Executive Officer appointed in terms of section 15. Chief Financial Officer means Chief Financial Officer appointed in terms of section 15. Companies Act means Companies Act 2008, Act number 71 of 2008. Competent person means a person who is qualified by virtue of his or her education, training, experience, and contextual knowledge to make a determination regarding the performance of a building or part thereof in relation to the functional aspects, and where applicable, approved and appointed in terms of the National Building Regulatory Relations Building Standards Act 1977, Act number 103 of 1977. Council means the juristic person referred to in Section 4, which comprises of the administration responsible for the management of the affairs and the execution of the operations of the council, the implementation of the provisions of this act, and which act under the strategic direction of the board. Day means a calendar day for purpose of Chapter 5, Part 2, and in all other instances, day means a business day, excluding the period from 16 December of any year to 15 January of the following year. Both days inclusive Saturdays, Sundays, and public holidays. Developer means a person or an organ of state who initiates or execute, or both initiate and execute a project with the aim to project one or more homes to housing consumer, including but not limited to A, any other delivery agent as defined in Section 1 of the Social Housing Act. B, a social housing institution defined in Section 1 of the Social Housing Act. C, any agent acting on behalf of that person, organ of state, other delivery agent, or social housing institution. Fund Advisory Committee means the Funds Advisory Committee established in terms of Section 38(2)(b). Home, it means a permanent structure intended to provide protection against natural elements and which is suitable to be occupied for residential purpose or partially for residential purposes by the housing consumer or leased out by any person, and includes A, structure to be occupied for residential purposes as contemplated in the definition of social housing and contained in Section 1 of the Social Housing Act. B, a residential section registered in terms of the Sectional Titles Act 1986, Act number 95 of 1986. C, a unit as contemplated in the Housing Development Scheme for Retired Persons Act of 1988, Act number 65 of 1988. D, a home forming part of a housing program initiated by an organ of state, the private, E, the private drainage system from home up to the municipal connection or up to and including conservancy or septic tanks. F, water service in relation to a home excluding the supply of water service from the point of supply to the point of discharge as a fixture and appliances. G, any building ancillary to a home, including but not limited to storerooms, covered walkways, garage, and common facilities. H, any retaining wall necessary to ensure the structural integrity of the home. I, any building or wall or swimming pool or common property adjacent to the home, but only if it has the potential to cause a major structural defect to the home. J, homes that are co-owned in terms of the Share Block Control Act, 1980, Act number 59 of 1980, or Property Time Sharing Control Act, 1983, Act number 75 of 1983. K, boarding houses. I, hostels. Home builder means a person who A, builds or undertake to build a home or to cause a home to be built for any person, including himself or herself. B, builds a home for the purpose of sale, leasing, renting out, or otherwise disposing of such a home. Irrespective of whether or not the person is registered in terms of this act, home building contracts means an agreement between two or more parties for the construction of a home, whether by prime or subcontract, and includes any form of contract contemplated in Section 48. Home building manual means the home building manual published by the council in terms of Section 86. Home warranty fund means the home warranty fund contemplated in Section 35.1. Housing Act means the Housing Act 1997, Act number 107 of 1997. Housing consumer means a person who has acquired or is in the process of acquiring a home for the purposes of owning a home, including but not limited to A, co-owner of a home, B, the owner of a section registered in terms of Sectional Title Deeds Act 1986, C, the holder of a housing interest as defined in Section 1 of the Housing Development Scheme for Retired Persons Act 1988. D, the beneficiary in terms of subsidy housing program contemplated in the National Housing Code. E, the beneficiary of housing development as contemplated in Section 1 of the Social Housing Act, including that person's successor in title. Housing Consumer Protection Measures Act means the Housing Consumer Protection Measures Act 1998, Act number 1998 of 1998. Informal settlements means an area where primary non-permanent structure have been erected for residential purposes, including but not limited to A, an unplanned settlements not having been upgraded in terms of the less formal Township Establishment Act, 1991, Act number 113 of 1991, prior to its repeal by Section 59 of the Special Planning and Land Use Management Act, 2013, Act number 16 of 2013. B, a squatter settlement. Inspector means an inspector appointed in terms of Section 770. Major structural defect means defects as determined in Home Builders Manual, which give rise or is likely to give rise to damage of such severity that it affects or it is likely to affect the structural integrity of a home and which requires complete or partial rebuilding of a home or extensive repair work to it, and a structural defect has a corresponding meaning. MEC means a member of the Executive Council of a province responsible for human settlements. Minister means the minister responsible for human settlements. MMC means a member of the municipal council of a municipality responsible for human settlements. Municipality means a municipality as defined in the Local Government Municipal Systems Act 2000, Act number 32 of 2000. National Housing Code means the National Housing Code referred to in Section 4 of the Housing Act 1997. National Regulatory for Compulsory Specifications Act means the National Regulatory for Compulsory Specification Act 2008, Act number 5 of 2008. Organ of state means an organ of state as defined in Section 239 of the Constitution of the Republic of South Africa, 1996. Person, in addition to the meaning attached to it in Section 2 and the Interpretation Act 1957, Act number 33 of 1957 includes a trust as defined in Section 1 of Trust Property Control Act 1988, Act number 57 of 1988. Prescribe means in relation to A, the minister prescribes by regulation, or B, the council prescribes by rule. Promotion of Administrative Justice Act means the Promotion of Administrative Justice Act 2000, Act number 3 of 2000. Public Finance Management Act means the Public Finance Management Act 1999, Act number 1 of 1999. Social housing means housing provided as contemplated in the Social Housing Act. Social Housing Act means the Social Housing Act 2008, Act number 16 of 2008. Subsidy housing means housing projects and programs contemplated in National Housing Code or any other programs funded by government. This act includes the regulations, rules, home building manual, and any directives in short in terms of this act. And technical requirements means technical requirements referred in this section in section 86.1 and technical standards have a corresponding meaning. The application of the Act. 1, the provision of this Act applies to A, the building of new homes, B, any addition to, alterations, renovations, or repairs of a home, insofar as such additions, alterations, renovations, or repairs necessitate the submission of building plans to municipality in terms of the National Building Regulations and Building Standards Act 1997, Act number 103 of 1977. Whether or not the home is acquired through social or subsidy housing, this Act does not apply to a dwelling unit that does not have its own bathroom or kitchen, B, any temporary building as contemplated in the National Building Regulations issued in terms of National Building Regulations and Building Standards Act 1977, C, a shack or caravan, D, any structure forming part of any informal settlements, E, a hotel, F, a motel. Number 3, notwithstanding the provisions or subsection, the minister must, by notice in terms of Gazette, determine A, in relation to a category of a home, a date, B, in relation to different categories of homes, different dates, when the provision of chapter on the provision of chapter 6, which applies to any addition to, alterations, renovations, or repairs of a home. Number 4, notwithstanding the provision of subsection 2 and 3, this Act applies to any addition, alterations, renovations, or repairs of which the purpose is to convert a commercial building or part of a commercial building to a home. 5, the minister may, after consultation with the council, in exceptional circumstances and in public interest, on such conditions as he or she may determine, exempt certain persons or homes from the provisions of this Act, but that exemptions may not be contrary to the objectives of the Act, of this Act. Application of Public Finance Management Act. Number 1, the council must prepare and submit budgets, financial statements, audits, and annual reports in accordance with the Public Finance Management Act. 2, the powers and duties of the board and the council must be exercised subject to the Public Finance Management Act. Okay, Chairperson, this is chapter 1.
Thank you very much. Can I check with members anything on the chapter 1, including on the starting with the definition and the title, the title of the bill and the definition? Can I get members to agree? Honorable Masuta?
Sorry, thank you, Chair. I just wanted clarity with regard to the powers of the minister as defined in the definition section. Firstly, she's able to issue regulations under the definition of prescribed, in as much as this council is able to issue what do you call them, rules. So that the meaning of the word prescribed would refer to both exercising their powers of that kind. And then I see in the second instance, the minister exercises her powers by way of directives. It is clear to me as to what is the procedure of issuing regulations and of issuing rules in terms of gazetting and all of that, promulgation thereof. Now, in terms of directives, can you just clarify what is the process that the minister follows for the directives to have the force of
I'm not
law?
sure.
Or simply
I'm losing you, Honorable Masuta. I'm not sure whether other people they've heard you for. I just heard you for.
Can you still hear me?
Yes,
Can I interject? Chair? Can I interject?
Yes.
I want to listen to Honorable Masuta well, but I want to request Sabelo, when someone is asking a question on a particular provision, she must take us to where that question is. If so that because you can't remember all of these issues. When speaks about the powers of the minister, she must take us to where is that in the, so that we understand where the question from the honorable member.
Okay. Okay. Honorable Swai, Sabelo will do that. Honorable Masuta, I said I've missed. You were cutting. I'm not sure if the members they've heard you.
Each time people disturb me with their calls and I dismiss those calls, I temporarily get cut, and I don't know if there's any way to block people from calling. Come from advertisers to all kinds of people. Each time they call me, there is an interruption. I try to reject their calls, but in the meantime, an interruption has happened. Am I still audible?
Yes, Honorable Masud. You are.
So forgive me, it's something I don't know if I have any way of controlling. But just to complete my point, it seems as if there's also over and above directives and regulations that the minister issue in terms of this definition section, that the minister can act generally, such as in giving certain exemptions that may relate to structures that may need to be exempted, for example, from the operations of the Act. Unless I've missed it somewhere, I just wanted to clarify, in those instances, would she be doing it by way of directives or legal instrument through which the minister can exercise her powers, other than those methods defining minister in relation to his or her exercise of her powers under the Act. If I could just be clarified on that question. Thank you, Chair.
Thank you, Honorable Masuta. Any other hands? None. Sabelo and the team that are here. Sabelo, you want to speak to what Honorable Masuta is saying?
Yes, Chairperson, I just want to bring up the bill, but it's the computer is freezing here. Just give me a minute.
But we have the definition on the screen, Sabelo.
Yeah, Chair, but here on me it's freezing. It's not showing, Chair.
Okay.
Yeah, just give me a minute, Chair. I'm gonna sort it out.
Or can I get
Yeah,
a legal
that's here, Chair.
person? Okay, you're fine.
Okay, so I'm gonna start again in let me go up first to the definition of the minister and the responsibilities, and then I'm gonna go down to the application. So with regards to the
Chairperson, I'm not
You've
saying
not-
Sabelo.
You've not raised the hands, Honorable Zeke.
Yeah, I'm okay. My
Your
apologies.
gadget, your gadget has problem.
No, I just thought maybe it's an interjection, maybe, Chair.
Okay. What is
Sorry, Chair.
Yes,
I was thinking that the question, without saying Sabelo will not be able to answer, but these are legal processes on regulations, which I thought maybe this is the right time where our legal gurus could come in to explain that process. Thank you, Chair.
Yeah, that's why I was saying Sabelo, and then the legal advice of Parliament will come after Sabelo. Sabelo, proceed.
I agree with you, Chair. That is the correct procedure.
Yes.
Okay.
Sabelo,
Thank
and
you.
then the legal person of Parliament.
So firstly, in this context or in this bill, the minister is described or it means a minister responsible for human settlements. And how do they Okay, so with regards to the provisions, the minister must, by notice in the Gazette, firstly, determine number A, in relation to a category of a home, a date. B, in relation to different categories of a home, different dates, when the provision of Chapter 6 will apply to any addition to, alterations, renovations, or repairs of a home. 4, notwithstanding the provision of subsection 2 and 3, this act applies to any addition, alteration, renovation, or repairs of which the purpose is to convert a commercial building or part of commercial building to a home. Number 5, the minister may, after consultation with the council, in exceptional circumstances, in the public interest, on such conditions as he or she may determine, exempt certain persons or homes from the provision of this act, but that exemption may not be contrary to the objectives of this act. Legal.
Just pause there, Minister, Chair, if I may. Sorry to do this to you. This is precisely what I'm trying to understand. When the minister grants these exemptions, when the minister...
Honorable Masuta, can we allow the legal person of Parliament to add on what Sabelo, and then you can then come up as a follow-up?
I just wanted to clarify the question so that even him understands what really the question is, but it's fine if you prefer it that way. I'll stand down.
Okay. Madam legal person from Parliament.
Thank you, Chairperson. Chairperson, if I may ask the honourable member to just clarify what exactly the question is. I would appreciate it, because it's not entirely clear if the question is the minister going to do these changes via directives or via regulations? Thank you, Chairperson.
Okay, Honorable Masuta.
That's precisely why I interjected, and Chair, you felt you should allow them to finish. I knew that question was going to come. I was anticipating it. But anyway, let me proceed to clarify. You see, there are specific provisions in this definition section where the minister exercises her executive power by way of subordinate legislation, which is regulations. There's places where she exercises powers by way of directives. And in those instances, those tools are specified, right? There are instances where the council exercises subordinate legislation through rules, and that's also specified. But it appears to me that there's instances where the minister is able to exercise powers, but it's not in all instances where the tools, the legal instruments through which she exercises those powers is specified. Are we supposed to assume that there is a general rule of interpretation that in such instances would clarify as to what tools in those instances where there is no specification as to how the minister is going to exercise the powers? I noticed that in some instances it says the minister must do so in the Gazette, and in some instances, such as the last sentence he read, I didn't seem to have picked up the word gazetting. So it seems as if there is varied circumstances under which, and maybe to avoid having to come back to this issue, do you rely on the Interpretation Act for how the process of subordinate legislation under this Act is to be done, namely that the Interpretation Act also expects such subordinate legislation to be tabled in Parliament? And I'm not sure whether there is requirement that Parliament approves or simply notes the draft subordinate legislation before it's promulgated. But that's a separate question, and maybe you may not want to deal with it now, but obviously to legitimize any subordinate legislation, it's either you're going to have to assume that the Interpretation Act takes care of it, or else you may need to specify here as to, apart from gazetting and in relation to the powers of Parliament, whether such draft regulations or subordinate legislation must first be tabled, and whether for approval or just for noting by Parliament. I hope I'm clarified myself at this time. Thank you.
Thank you, Honorable Masuta. As I give the the legal person of parliament to respond. The latter part of the question, the committee can decide, because if you remember that there were instances where members would have a problem with the regulations that dilute the essence of the bill. So it's upon us to take that decision, that as the minister is going to draw those regulations, we must actually table them to the committee, not for noting actually, for us to be able to see whether they don't actually dilute the essence of the bill itself. So the answer is with us. I'll give the legal person to respond on the other issues.
Thank you, Chairperson. You are 100% correct with regards to the very last question raised by the Honourable Masuta regarding the regulations and the role that Parliament would want to play. So it is for us, it is for the committee to decide how we want to structure the promulgation of regulations. So all we need to do is just add on there to say that Parliament needs to be a part of that process for the very reasons that you mentioned. And then moving on to the main question regarding regulations and directives and gazetting and the Interpretation Act. Chairperson, I've always believed that in terms of legislation, especially legislation that's so important, and given the nature of this legislation, that it needs to be understandable, and lay people need to be able to know what this act is saying without having to have regard to interpretation acts and the like. So my suggestion would be that where it speaks about the minister exercising powers, we need to say how the minister is going to be exercising those powers. So specifically, if we look at subsection 3, that's flighted on the screen there, it says, notwithstanding the provisions of subsection 1, the minister must, by notice in the Gazette. So that's perfect because it says how it must be done. So, and then if you go down to 5, it doesn't specify. So it's for us as the committee to add in the specifics to make it more understandable, more accessible to members of the public, because this bill really impacts on them the most. Thank you, Chairperson. So we can add, as far as I understand and my advice goes, we can add the specifics about how exactly the minister is going to be doing and exercising these powers. Thank you, Chairperson.
Thank you very much, the legal person. Honorable Masuta, you still want, there is Butas, there is Honorable Butas Seki, there is Honorable Masuta still on the platform. Who was calling me is Honorable Malmat.
I was covered by both of you and the legal advice. I'm fine.
Okay. Honorable Butas Seki, and then Honorable Masuta will follow. Is it legacy hand?
Chair, I think mine was the earlier one.
Or is the legacy hand? Honorable Masuta, is it the legacy or you want to come back?
It's a follow-up question, Chair.
Okay, all right, thank you.
I think that what the Chief State Law Advisor, if that's the ladies, or is it parliamentary legal advice? I'm not sure. But
It's a parliament legal advisor.
yes, I agree entirely with her response because it is legally correct. But I don't think that the answer should come from us as the committee. That is the last part where the bill does not specify how the minister exercises her powers in those instances where it doesn't specify. So I think before we, as this committee, jump into that wagon, let's allow the department who are the architects of this bill to clarify what they had in mind. Maybe there is another third method or legal instrument that they envisaged through which the minister can exercise powers other than those that have already been discussed before we delve into prescribing to them whether we think regulations or directives or rules would be the appropriate tool where that has not been specified. And also they must specify why in this instance there's no reference to promulgation, namely gazetting at sub 5. Thank you, Chair.
Thank you, Honorable Masuta. State law advice. Can you come in?
No, the question is directed to the department, to the drafters, actually, Chair, if you don't mind. Before the state law advisors can jump in. If you allow, please.
Okay. Department. I'm not even sure who's here, because we had engaged the department ourselves, and then we didn't. Or DDG Shaney and Litsolanyane, they're here. Let's
And Paul
DDG
is here,
Cheney.
Chair.
Yeah.
Of
And
the
Paul, Chairperson.
department, not yet. Sorry to interrupt.
No.
This question
speaking?
is directed to the drafters themselves. It's Masuta. I'm saying the drafters from the department themselves. Before.
That's what I'm doing, Honorable Masuta.
Okay, I thought I heard you say Chief State Law Advisor coming.
But he has certified the bill itself. He has the. You can have the answer why it's like that, because yes, he has satisfied the bill for
Anyway,
it to be
if you prefer it that way.
Yes.
If you prefer it that way, then that's fine, Chair. Thanks.
Okay.
I'll abide by your ruling.
Yes. Honorable, sorry, the legal advisor. No. Who's this? Yeah, legal advisor of the department is Paul.
Thanks, Chairperson, and yes, honorable members of the committee. I think it may not have been included there, but in clause number 87, it talks at length. Maybe should I just read it? It talks about the fact that minister must gazette the regulations, which must be published for not less than 30 days when publishing regulations. Section 88 deals with the board or on recommendation of council rules. So that's it is covered in those sections. So that's why perhaps it may have been left there, because at the later stage, it is covered as to how they need to be done. Thanks.
No, that is not the question, Chair. Sorry to interject. I think this parliamentary advisor understood the question and proffered an answer. We just wanted to confirm with the department if the answer given is consistent with their thinking. That was the question. And I don't think that the answer that's been given here understood what the question was and what the response and the advice from the
But
parliamentary
Honorable
legal
Masuta,
advisor, which was correct,
Honorable
was
Masuta,
saying.
Honorable Masuta, please
Yes, Chair.
allow me to
Yes, Chair.
chair the meeting because we have to progress at some point. That's why I was saying I give the department and then I give to the state law advisor who has certified the bill for him to add on the poll. And then if you are not satisfied, then you'll then come back. So that we don't have a dialogue. Yes. The chief.
I stand down.
Okay, thank you very much. Can we then have the chief, the state law advisor to talk to the issue that the Honorable why you have not specified on these other areas where the minister has to
Thank you, Chair. I'm Sisa Makabeni, the State Law Advisor. There are two instances, Chair, that are foreseeable where the minister may make the exemptions, Chair, that are contemplated in that section. One instance would be where there's an application, Chair, that would be made. And then in that one, the minister would deal directly with the application. But where it is the minister has to deal with a general exemption, Chair, an exemption that applies general. Then in terms of Section 15 of the Interpretation Act, the minister would have to publish a notice in the Gazette in that regard, Chair. So those would be the two instances, Chair. One would be by way of an application, and the other one would be where there's a general exemption being given. Then the minister would act by notice in the Gazette, and that is taken care of by Section 15 of the Interpretation Act. Thanks, Chair.
Thank you, the state law advisor. I've missed the name,
Sisa Makabeni, Chair.
Oh, Sister Makabeni. Thank you very much,
Yes,
Sister Makabeni. And then Honorable Masuta, if you are not happy with the answer, please propose what you think should be so that we can then start to deliberate on what you think we should how it should reflect.
Yeah, I think that the legal advisor from Parliament was spot on when he's saying there should be simplicity. The new way of legislative drafting is to ensure
Not sure if my gadget, because
assume what
I
you
can't
mean,
hear Honorable
but you
Masuta.
specify what you mean. So if in this instance that means implication, that question.
Honorable Masuta.
Am I still not audible? Am I still not?
Yes.
Am I still not audible?
Now.
Am I still not audible?
Now we can hear you. We're losing you. Proceed.
I think that the legal advice from the parliamentary advisor was spot on, in that where we talk of the minister in circumstances which have just been described, which is where you're dealing with individual applications for exemption. If that is really the purpose of that subsection, subclause, then let's say so. Simple. Let's not let people to assume in what context the minister exercises a power here, right? And of course, it would then make sense why the minister wouldn't need to gazette such an exemption, because it's an individual request. It's not meant for the general application. So I understand that, but then let's then specify that in instances where an individual is unable to comply, the minister may grant exemption with at the request of such a affected individual, which is what the chief state law advisor is saying. I agree with him, except I agree with the parliamentary advisor that in that instance, then why not be specific about it? I think that's good and drafting practice. Thank you, Chair.
Thank you very much. Any other issue on the chapter 1? Honorable Malimatsa?
No, thanks, Chairman. I just want to open it this way so that sometimes if we don't put it in a form of figures, we end up making mistake. The issue of individual, say for an example, this matter, it has to deal with not necessarily individual, but it has to deal with an individual location, which on its own is an individual location outside the broader location. What actually becomes a problem that the very same exemption, it be applied the same in a way of avoiding us being taken to court here and there, because somewhere will be notified to say, here it was applied here, the minister's powers were applied this way, here the minister's power were applied differently. And in this case, it's not necessarily individual home, it's individual location within the province, as I have to give that. What make it fast that it is not done uniformly, so that at the end of the day, we avoid being taken to court and go and clarify us there. Thank you, Chair.
Legal teams, both the state law advisor and the parliamentary legal advice. Can you help us to summarize the matter so that we can pass? Any one of you can start.
Thank you, Chair. It's the State Law Advisor, Chair. I think, Chair, to be on the safe side, the provision would still need to make a provision for both scenarios, Chair, because there may be a scenario where it is required that you give a general exemption. And then there may be a scenario where you're dealing with a specific case or an individual case or yeah, let's call it specific, Chair. You're dealing with a specific case where you would need an application to deal with a specific application. So I think that there would need to be that distinction. The department would be able to advise us if our understanding is correct in that regard, Chair.
Thank you. Parliament.
Thank you, Chairperson. I'm in complete agreement with the State Law Advisor. We need to make the distinction, and we will be guided by the department in possibly redrafting that clause. Thank you, Chairperson.
Okay, department. Can we agree that? Okay.
Thanks,
Mr.
Chairperson.
Yes. Yes.
Yeah, I think agreed with colleagues that will be included. Thanks.
Okay. Okay. Thank you very much. Let's agree that the clause would have to be put the way the legal both the legal teams are reflecting, which it will then be easier for everybody to understand. Can we then pass if there is any other matter on chapter 1? Mr. Malemaza, I see your hand still up.
It will be legacy. It's just Comrade Chair. I'm not sure if, you see, sometimes if people are not ready for answer, I must say, let's consult, we'll come back, because I post this with the experience of us being taken to court, in and out of the court for clarification. But if maybe it's me who is bit backward, I'm fine. But if I have to say it, that it can be, because individual and the location are two different things, and it cannot apply one and the same approach on that. But let's agree to progress, Comrade Chair.
Yes, I think what we'll do as we would then, Honorable Masuta.
Just to assist Comrade Malemacha, who has a very valid point, but to some extent the point has been answered. What remains is that it may well be that the procedure for dealing with an individual might need to be slightly different from the procedure that deals with a locality. So he is spot on to say to the department and the drafters, but especially the department, because these things are policy issues. It's a matter of choices. And the department holds that final responsibility. So they may need to reflect more and say, have we regulated sufficiently? And how does this apply in relation to the other powers of the minister, where she or he regulates localities by way of regulations and other subordinate legislation, directives, etc. Could this be an area which should not be lumped together with a situation that was explained by the Chief State Law Advisor, where an exceptional situation that applies to an individual has to be entertained? But just to conclude by saying, I entirely agree that we should never lock out individuals from being able to approach the minister in meritorious circumstances. That, I think, is good law. Thank you.
Hello, Chairperson.
I can't hear Comrade Masuta anymore.
Oh, no.
Comrade
Thank
Masuta
you
is
very
done. I'm done.
Thank you very much, Honorable Masuta. I was saying that Sabelo, where members are raising issues, I think let's put it the red flag, so that next time when we finalize, we are not started to yeah. It must be highlighted, and then we'll, as we finalize, we'll then take cognizance of what the issues were raised and how we think it should be then drafted.
Yes, Chair.
Highlighting,
Sorry.
yes.
Sorry, Chair, I'm using the PDF format here, but I'm taking notes on my notebook as members are talking, Chair.
Okay, all right. Okay, no, thanks. I thought it was going to be easier because Collins, why it's here, he's got a bill now. He must help you to pick up those issues so that they don't get lost in the process of as we're dealing with the bill. Let's
But why
proceed.
don't we use the word version of the bill?
Any other matter on chapter 1? Can we pass?
Chairperson, it's Honorable Powell. My hand is up.
Oh, I didn't see it. Thank you, Honorable Powell, and then Honorable Zeki followed. Yes, Honorable Powell.
Thanks, Chair. In terms of the application of the Act, this where Kaliswa is busy doing the edits on the PDF, I would like to ask on page 11 of the submissions that were given to us from the National Department, on page 11, one of the comments that came through from the public hearings was the exclusion of rural communities in terms of the application of the Act. Now, I note that the Act does not apply to an informal settlement, but there is no exemption in terms of the application of the Act to a mud hut in a rural area, but there is an exemption for a hotel or a motel. I would like to ask whether or not it is responsible of us as a portfolio committee to not make comment on whether or not we think that the application should include or exclude a mud house in a rural area. My submission here, and I'm open to suggestions or discussion, would be that if we are to exclude a structure that forms part of an informal settlement, that we make similar provision for the exclusion of a mud hut in a rural area, given the challenges faced by rural dwellers in terms of accessing enrollment registries, the fines that apply, etc. So I just want to find out what the committee's views on mud houses in rural areas are, and then more so whether or not we believe it's prudent for the Act to exclude a hotel or a motel. If it does cover commercial buildings, why are we giving exemption to hotels and motels? Thank you, Chairperson.
Thank you, Honorable Powell. Honorable Zeki.
My question is on temporary structures. Maybe I missed that. Where does temporary structures falls? Should they be registered or what? If that that can be explained, Chair, on the temporary structures. What's their, are they excluded or they're included in a different form?
Mr. Masamula, followed by the state law advisor, and then followed by legal person of parliament.
Thanks, Chairperson. The temporary structures, Honorable Tseki, are actually being excluded because they are actually temporary by their nature. It's not the structure that is intended to be built in terms of this bill. So they are excluded. The motels and hotels, or rather the commercial buildings that are intended in this thing, is the ones that are being turned to residential areas, purposes. So it would, for example, there are instances where there would ordinarily be a building that was been there for business purposes, but then for commercial purposes, then it's been turned into housing units. So I think that's what it was intended for. I think my other colleagues, I have Natasha from NHBRC, who may also add on some of the issues that we are dealing with. Thanks, Chairperson.
State law advisor and then followed by Parliament.
Thanks, Chair. I think the gentleman from the department has adequately answered it, Chair. Thanks.
Thank you, Chairperson. I'm in agreement with the department and the SLA on the explanations given. Thank you.
Chairperson. Hi, Chair.
Yes, Honorable Chafen.
Yeah, I don't know, Noguchi, my hands is not raised now because I raised the hands courtesy, but since
No,
in
no,
China,
it's not visible, Honorable Chafen.
Come again, Chair?
Your hand is not visible on the screen that you have raised the hand. You can talk.
I don't know what's going on in this chapter. Okay, Chair. I have a concern, Chair. As a committee, I rove in the country talking about the consumer protection bill. So the people outside there is many issues. So I want to know when the minister is seated with the committee and debate about those issues of the people outside there. And in the department, I want to know about the temporal structures. But when it comes, you give the person the temporal structures, you are registered that temporal structure now. Because in the rural areas, we have many temporal structures that are not, as in 2010, we have temporal structures in the Eastern Cape until today. So ngiyafuna ukuthi department isicacisele ukuthi those temporal structures ziphelelwa nini or else ziphela ziyi-permanent for umuntu angakwazi ukwakhelwa indlu na. I thank you, Chairperson.
Mr. Masamula.
Thanks, Chairperson. On this one, I would ask I'll delegate upwards, Chairperson, to the DDG to assist on it. DDG.
Afternoon, morning, Chairperson, morning, honorable members. Chair, in relation to, and I'm assuming that the Honorable Tafeni is referring to that I think the temporary structures, we must be clear about it. If we are talking, for example, of the temporary residential units that the department constructs, those in terms of the process, the NHBRC does not have, in terms of the structure, and the colleagues will address this, that in relation to the NHBRC, their responsibility and their function is primarily to ensure the warranty and the integrity of a permanent structure which is intended to house people permanently. In the case of a TRU, with specific reference to issues of the construction as well as the building of that, there are other regulations and there are other acts. So there's occupational health and safety, there's the building regulations, there's the civil engineering. All of those cover that aspect. Where a household puts up a temporary structure, that is not intended to permanently house a household, that is not covered by the NHBRC, because remember the NHBRC covers permanent structures, not temporary structures of any nature. So when we look at that, the responsibility and accountability must be looked at in terms of what the other acts are, with specific reference to erection of a structure, as well as the civil engineering and all of the other matters that are attendant to that. So no. Thanks, Chair.
Chair, is my hand visible to you? I had
No,
my
no,
hand up.
I see Honorable Masuta, his hand is up. Honorable Masuta, and then you'll follow Honorable Nancy.
Okay.
I would have deferred to a veteran out of courtesy. But I'll obey your. No, Chair, I think that the question remains valid from Honorable Tafeni, who asked the question about temporary structures. I think what she's trying to understand here is that, yes, trade and industry may be responsible, and probably the Department of Labor, for safety when it comes to construction of any kind through their respective regulations, and the soundness and safety of structures and issues like that. But it is clear in this bill that where the mandate relating to the erection of structures falls under human settlements, namely residential forms, then the department can defer that responsibility to the others, especially if the temporary structure was erected by them. They need to actually say to us, what then? What is the meaning of temporary? And if a temporary structure is there for 10 years, in relation to this bill, what is the implication? Are they directing in this act that a structure, because it's temporary, may not be allowed to exist for longer than a particular period? And if so, must it be demolished, and by who? And if they're not ready to replace it with a formal house, what happens to the accommodation of the people who have been staying in the temporary structure in the interim? Because then automatically they become homeless. So those are the questions really, as I understand Honorable Tafeni, that are right at the doorstep of the department. It's not about engineering here. It's about what, when you exempt temporary structures, are you then saying in relation to the longevity of its continued existence? And if they have to be demolished, what is the alternative that you're offering in the event that you might not be ready to move those people for whatever reasons, budgetary and otherwise? And it brings back the debate about financing and the financial implications of this legislation. But let me pause there. And if I misrepresented Honorable Tafeni, my apologies to colleague. But that's how I understand where she's coming from. And I think that issue has not been dealt with. Thank you, Chair.
Thank you very much, Honorable Masuta. Honorable Tafeni. Yes, Honorable Mo.
Thank you,
Sekhwai,
Chair.
sorry. No, let's give Sekhwai first. He has raised the hand before you, then you'll follow.
Thank you, Chair. This is a very, very tricky debate, Chairperson. Maybe it perhaps we should be able to get the clear definition, and the basis of that definition must be explained to us. The speaker who just spoken now made an example of TRUs. TRUs have utilized my right in value terms, my money, a subsidy amount, and they are registered in my name. And they continue to be called temporary houses. It's going to be very important that we clear that well, because also the Act talks about the informal settlement. The department is busy to deal with the issues of informal settlement, upgrading them. As to how far they're going to be upgraded and be registered in my name. It goes back, Chairperson, please apology for my lengthy speech, that this is tricky in terms of our history and where this bill find ourselves in. So if there could be a clear explanation, the temporary house, the informal settlement, the TRUs. How do you differentiate between those in terms of the housing consumer protection? Thank you, Chair.
Thank you, Honorable Mokoto.
Thank you, Chairperson. I would also like to add something with regard to, or I need clarity with regard to the TRUs. What I want to know is, does this bill also cover the TRUs? Because TRUs are homes where people are staying and they have been built by the Human Settlement Department. For example, if there are any defects in these TRUs, does this bill cover, those defects? Who is responsible, to repair those defects? Are they covered? That's what I want to know. Like in this bill, there is a warranty that is given to the subsidy houses. Now, I want to know if in the TRUs, these TRUs are also covered by the warranty, which is included in this bill. Thank you.
Mr. Masemola and Mr. Cheney, and elaborate further on the issue of the why exactly you excluded the hotel.
Thanks, Chairperson. I'll allow first Natasha to come in. Perhaps DDG to also follow.
Natasha.
Good morning, Honorable Chairperson and Honorable members. In relation to temporary structures, as was alluded to by Mr. Cheney earlier, the NHBRC in its daily operations only deals with permanent structures, which has been, approved in terms of your town planning, that has approved plans. The NHBRC, does not deal with temporary buildings at all. However, Chair, if you allow me, there was an issue in relation to an hotel and why it is excluded, Chair. Generally, an hotel provides accommodation on a temporary basis. It's not considered, a dwelling unit. It's operated as a business, and it provides temporary residence for guests, and it's not intended to provide a home for a housing consumer as defined in the bill. In this regard, the hotel also provides short-term accommodation with meals and other services such as your cleaning and laundry facilities. Chair, I'll now hand over to Mr. Masamola and the department on the issue of the temporary structures. Thank you.
Chair, if I could assist. Chair, if you look at the Act, you'll see there on the screen, it says, notwithstanding the provisions of subsection 1, the minister must by notice in the Gazette, A, or determine in relation to a category of a home a date, and in relation to categories of homes different dates, when the provisions of chapter 4 will apply to any addition to alteration, renovation or repair of a home. Now, the point that is being raised around the question of the TRUs is where that has come up, because I think what members of parliament are saying, and I think it's consistent with this contradiction that will arise, that a temporary structure is or TRU in terms of the housing programs, for all intents and purposes is a home. For all intents and purposes must consist of the relevant building plans, must comply with all of that, because if it doesn't, it will not fall or will not comply with the National Housing Building Regulations. Now, in relation to, as we see on the screen, subsection 3, you'll see that the minister must by notice. So in relation to that, may determine a category of a home a date, and in relation to different categories of homes, different dates. So it does not preclude the ability of the minister to do so in instances where that arises. But I don't think what we want to be able to do is allow the minister to determine that, or us as government to have a blanket approach. All temporary houses, irrespective of whether government knows about it, whether municipality or province knows it. So I think in relation to what
Sorry, Mr. Cheney. Honorable Masuta, can you close your mic? Honorable Masuta.
Apologies,
Okay. Proceed, Honorable Mr. Cheney.
Yes, Chair, because I think the point that we've raised, and I think it's an issue that hence this clause is in here, is that in the case of a TRU, it meets and ticks all of the boxes with regards to building plans, with regards to, even if it's temporary, there must be those things. So the point about it is the minister, and I suppose this is one of the issues that we're going to have to be able to come back to the portfolio on, is does it go into a gazette? Because it would mean that every TRU, every temporary residential project is then put or is gazetted to form part of the NHBRC's responsibilities and accountability, Chair. But that is something that we've considered, and I suppose we'll take guidance from yourselves in terms of the directive on that part. Thanks, Chair.
Thank you very much, Mr. Cheney. Let me give the state law advice and parliamentary advice, legal advice. on the matter. But just to say that I think we should remember, even if Natasha is saying that they are not dealing with the temporary structures, when there was a problem in Dalani, you were the people that went there and raised the issue of quality. And for me, to say that you are not dealing with that, it's not truly correct.
Hello, Chairperson.
We've lost the chair.
We've lost the chair, ne?
I think we have
Chairperson
lost
here.
Chairperson.
Now, when we lose the chair, that is that time where I chair.
No, she's back.
Okay, sure.
She's still struggling.
We are struggling, Chair. We are struggling to hear you, Chairperson.
Natasha, it says that I'm saying, do you hear me?
Yes, Chair.
And I was saying that Natasha's answer that they are not dealing with the TRU is not entirely correct, because when there was they provide quality assurance, and when there was a problem of Dalana, they themselves was instructed by the department to go and look at the TRUs that were built by in Limpopo by that Utalana project, and they provided a report which guided the process forward. So the issue that they are not dealing with the temporary structures, is it? I don't think it's correct. It's not. It's not correct, because when they would, if there are floods, if there are problems, you end up find yourself attending to those issues. Can we get the state law advisor and anybody from the department before we give it to the legal person of parliament?
Can I just add a point, Chair? I raised my hand so that they can respond holistically on the same issue.
Okay.
And I just wanted to indicate in support of what you're saying that temporary structures here, as I understand it, and they can clarify it, mainly relates to the work of the department itself. And my understanding is that where accommodation is provided by the department, whether for temporary or permanent purposes, this legislation also is self-regulating in the sense that it's regulating, the department is regulating itself on its own work. And therefore, I cannot see how it can then shed its own responsibility in circumstances where the work was done by it, especially to somebody else. But it also applies in cases where in the course of constructing a permanent structure to become a residential home, which is covered by them, a temporary structure may be erected for purposes of those who are involved in the construction of the home. Does that temporary structure suddenly become the responsibility of somebody else and not the department when its sole purpose is to house those that are producing ultimately a home that would be regulated by the department. So there's a number of questions here. And the third category, of course, is where a person builds a temporary structure with the hope that when they have the money, they'll eventually graduate themselves into a permanent structure. But they end up in a temporary structure for the rest of their lives. I don't mind the department using the exemption provisions there, but they can't simply say it's not their business. It's somebody else's business. Whose business is it? Because my understanding is that anything to do with human settlements, in other words, accommodating humans for dwelling purposes, that falls within the mandate of this department and not trade and industry or any of the other departments. Thank you, Chair.
Thank you, Mr. Masuta. Honorable Zeki.
Chair, look, this matter has got a lot of interpretations, but my understanding is that temporary structure, as the name dictates, it's not permanent. And therefore, regardless of this period that temporary structure is still the responsibility of the department. So I was thinking that that's the understanding. If the person staying in that temporary structure has got a grievance against its standing, that person will automatically go to the department. The period, of course, it will be dealt with the department, not the NHPRC. Thank you, Chair.
Thank you very much. The state law advisor, and then followed by the
Thank
Parliament.
you, Chair.
Yep.
Thanks, Chair. The issues that relate to the scope, Chair, of the legislation and how far it goes and what it covers, Chair, issues of policy, Chair, that we do not get ourselves involved in. Safe to say, Chair, I think we should just be mindful that there are various pieces of legislation that regulate various aspects of the building of houses. So there would be the national building regulations, Chair, that are administered by municipalities as well, that regulate certain aspects of housing. So there are different regulators that relate to different issues of housing, Chair. So I think we should just be in the discussion be mindful of that part, Chair. That the fact that it's not covered by this one, it doesn't mean it is not regulated somewhere, because you would still need to comply with those standards that are set under that piece of legislation, and the local government inspectors would still need to oversee those processes, Chair. Thanks, Chair.
Thank you very much. Yes.
Thank you, Chairperson. I'm in complete agreement with what the State Law Advisor has said. The discussions that have just unfolded now relates to policy and not legal. However, having said so, I'm of the view that just having regards to the scope of this particular bill and the definition relating to a permanent structure, I think there may be issues of capacity, and it's a floodgates argument for the NHRBC. If they were to include the temporary structures, I'm not sure that they would have the capacity. But just in terms of this scope of the bill, it's limited to permanent structures. So going forward, that's what we would have to be mindful of, just in terms of the scope of this particular bill. Thank you, Chairperson.
Honorable Masuta and Honorable Zeki and Honorable Masuta, is it legacy hands?
In my case, I've just raised the hand again.
Okay, Honorable Zeki. Okay, Honorable Masuta.
Yes, Chair. Pardon me for chuckling here. The word floodgate and the word there are other laws and other institutions which are involved in regulating and enforcing regulations by implication relating to the built environment generally, is evading the issue. What is at issue here is the fact and the reality that this department could have chosen to say, we provide houses, we don't deal with engineering issues relating to structural integrity, relating to soundness of built structures. Ours is just to allocate houses and to fund them, and compliance with any other regulatory. Am I still there? Hello, am I still
Yes,
audible?
you are, Honorable Masuta. Proceed.
And said that all other matters which are regulated elsewhere already, like in terms of building regulations and building standards act, that these matters will be deferred to those departments and municipalities and the laws that they administer. But this department took it upon itself to actually, in part, deal with those issues of structural defects, which are engineering issues, which means that they decided that they will have the capacity, as long as it has to do with residential, whatever definition of residential is applied, take full responsibility for all aspects relating to the allocation, licensing, approval, possibly even directing demolition where structural soundness is of such a nature that it poses a risk to people's lives and all of those things. They've taken upon those responsibilities. Now they can't midstream say, yes, but when it comes to something we call temporary, and whatever the definition of temporary is, we do not, we wash our hands off, we leave it to the other departments. And those departments are not here to defend themselves here. And that is my worry. And that's why I once raised a question to say, to what extent has there been coordination and consultation between this department and the other departments who deal with regulating? Because it's not sufficient to simply say there's a provision in some act that's administered by some other department. Have you consulted with them? Are they understanding and accepting that where you don't come in, they automatically come in? Because we'll have a ping pong situation where trade and industry says, well, it's none of our business because it has to do with residents. Residents is human settlements. And then human settlements say, well, our law exempts this because we only deal with permanent structures. And in the meantime, if people's lives and their safety or comfort is at stake, that's where the cracks begin to come in the way government operates. So the department must really come clean here and tell us really who takes responsibility. You can't just tell us about the Building Regulations and Building Standards Act or any other law that's administered elsewhere. It's not good enough. Thanks, Chair.
Thank you very much, Honorable Masuta. Honorable Zeki.
Chair,
Honorable Zeki, yes.
I'm not sure whether the intention of this meeting today is to conclude everything. I think earlier there was a view that some of the issues we can note. I think we have exhausted this item in my view. Let's note it and then allow all parties to go back and rethink and come up with a good formulation. Thank you, Chair.
Agreed. Members, thank you, Honorable Zeki, for the way forward. We'll note that. Let's go to chapter 2. Sabelo.
Chapter 2, National Home Building Regulatory Council. The National Home Builders Regulation Council.
Sorry, Sabelo. Honorable Powell, are you answered on the issue of hotel? Are you fine? Honorable Powell?
Honorable Powell is no longer on the platform, Chair.
But is here on the system.
I'm here on the platform, Chairperson.
Yes.
Sorry.
She normally runs away and come back, so don't worry.
Zeki, you need to stick. You've already got a warning with the speaker from last week. I suggest you pipe down. Chairperson, I'm here on the platform. Can I help you?
Yes, I was saying, are you answered on the issue of the hotel?
Sorry, yes, I was on a phone call with the parliamentary IT guys. Yes, I'm answered. Thank you, Chairperson.
All right, thank you.
Okay, chapter 2, National Home Building Regulatory Council. The National Home Builders Regulation Council, established in terms of Section 2 of the Housing Consumer Protection Measures Act, continues to exist as a juristic person known as the National Home Building Regulatory Council. The board is the accounting authority as contemplated in the Public Finance Management Act. The council must act independently and report in accordance with the Public Finance Management Act. Objectives. Objectives of the council are to A, represent the interest of all housing consumers. B, regulate the home building industry. C, ensure structural quality of homes in the interest of housing consumers and the home building industry. D, promote housing consumer rights. And E, provide information relevant to stakeholders in the home building industry. 2,
Sabelo, we've lost you. Is it me or we've lost Sabelo? Sabelo.
He's still on the platform. I don't know what's happening, what's going on.
Can you
Chair?
call us on? Can you call him, call us on?
Yes, Chairperson.
Chairperson?
Yes, Sabelo, you can
Yes,
continue.
Yes, my apologies, Chairperson. Somehow I just got kicked out of the system. Okay, so I was dealing with composition of the board. The affairs of the council must be overseen by the board, which must, subject to the provision of this act, determine the policy and the objectives of the council and exercise control generally over the exercise of its powers, the performance of its functions, and the execution of its duties. The board consists of at least 7, but not more than 15 non-executive members appointed by the minister in terms of subsection 4. The board must, when reviewed collectively, consist of persons who have special knowledge and experience in consumer protection, B, the planning of human settlements, C, the regulatory and the legal environment applicable to this act, D, social housing, E, subsidy housing, F, town planning, G, home building, the supply of housing goods and services, and the role of associated professionals, including developers, in the provision of housing, H, the insurance industry, I, corporate governance and management, and J, financial management and management of funds. The minister must appoint the members of the board only after inviting nomination of persons as candidates through the media and by notice in the Gazette, and following as fair selection process. The minister must designate one of the appointed member as a chairperson and another as a deputy chairperson. If the chairperson is unable to perform his or her duty in terms of this act, the deputy chairperson acts as a chairperson of the board, and while the deputy chairperson is thus acting, he or she exercises all the powers and performs all the duties of the chairperson. The chief executive officer and the chief financial officer are ex officio member of the board, but may not vote at a board meeting. The board must perform its function in accordance with the code of conduct prescribed by the minister for the board in terms of section 90.1. Term of office. A member of the board holds his or her office for a period of 3 years, and that member may be reappointed at the expiry of his or her term of office. A person may not hold office as a member of the board for more than 2 consecutive terms. 1/3 of the members of the board must be reappointed, but it is not possible. But if it is not possible to do so, a number as close to 1/3 of the members as possible may be so appointed. When a vacancy occurs in the ranks of the members of the board appointed in terms of section 6.4, the minister must fill the vacancies for the unexpired part of the period for which the member's predecessor was appointed by the appointment of another person who has special knowledge, skills, or expertise similar to that possessed by his or her predecessor, as contemplated in section 6.3. Notwithstanding the period of the term of office referred to in subsection 1, any member holds office until the minister has appointed another member to replace that member after the expiry of his or her term of office, provided that such extended period does not exceed a period of 6 months after such expiry. Disqualification, vacations, and removal from office. A person may not be appointed as a member of the board if he or she, A, is not a resident of the Republic, B, is an uninhabited insolvent, C, is declared by a court to be mentally unfit, D, is convicted in the Republic or elsewhere of any offense involving dishonesty, E, is removed from a position of trust on account of misconduct that involves dishonesty. Number 2, a member of the board must vacate his or her office if he or she becomes subject to any disqualification mentioned in subsection 1, becomes an office bearer as defined in section 1 of the Independent Commission for the Remuneration of Public Office Bearers Act 1997, Act 55, number 92 of 1997. C, tender his or her resignation as a member to the minister, or D, has been absent without leave of the board from three consecutive meetings of the board. 3, the minister may, in writing and after following a fair process, remove a member of the board from office if he or she, A, has transgressed the code of conduct contemplated in section 90.1, B, did not comply with his or her fiduciary duties in terms of section 9, C, commits an act of financial misconduct as contemplated in the Public Finance Management Act, D, has been found guilty of violation of any law, or E, has become unable to perform his or her duty in terms of this act. Fiduciary duties and disclosure. A member of the board on appointment must submit to the minister and the board a written statement declaring any direct or indirect financial interest which could reasonably be perceived to compromise the objectivity of that member in execution of his or her duty as a member of the board. 2, a member of the board may not be present or take part in the discussion of or the taking of a decision on any matter before the board, including a committee or subcommittee of the board that he or she has been assigned to, in which that member or his or her spouse, partner, close family member, business partner, or associate has a direct or indirect financial interest. 3, if a member of the board acquires an interest that could reasonably be perceived to be an interest contemplated in this section, he or she must immediately in writing declare that interest to the board, and if applicable, to the committee or subcommittee to which he or she has been assigned. 4, a member of the board must at all times exercise utmost good faith, honesty, integrity, care, and diligence in performing his or her function as a member of the board, and in furtherance of this duty, without limiting its scope, A, must take a reasonable step to become informed about the board, its objectives and functions, and the circumstances in which it operates. B, must take reasonable steps to obtain sufficient information and advice about all matters to be decided by the board to enable that member to make conscientious and informed decisions. C, must regularly attend all meetings. D, must exercise an active and independent discretion in respect of all matters to be decided by the board. E, must exercise due diligence in relation to the business and necessary preparation for and attendance of meetings of the board and any committee to which that member is appointed. F, may not engage in any activity that may undermine the integrity of the council. And G, must treat any confidentiality matter relating to the council obtained in his or her capacity as a member of the board as strictly confidential and not divulge them to anyone without the authority of the board or as required as part of that person's official function as a member of the board. 5, this section must be interpreted as adding to and not diverting from the duties imposed on members of the board in terms of the Public Finance Management Act. Remuneration of members of the board and compliance and enforcement committee. A member of the board or the compliance and enforcement committee who is not in the full-time employment of the state may be paid from the council's fund, the remuneration and allowance as determined by the minister in consultation with the Minister of Finance. 2, a member of the board or the compliance and enforcement committee who is not in the full-time employment of the state may not, in respect of the duties performed by him or her as member in terms of this act, be paid any remuneration in addition to his or her remuneration as an employee of the state. Nor may he or she be paid any allowance in respect of subsistence and transport at a rate exceeding the rate applicable to him or her as such an employee. Meetings of the board. Number one, the board holds meetings at such times and places as may from time to time be determined by the board. Two, the chairperson, or in his or her absence, the deputy chairperson presides at every meeting of the board. Three, if both the chairperson and the deputy chairperson are absent from a meeting of the board, the members present must, from amongst their members, elect a person to preside at the meeting. Four, the quorum for a meeting of the board is a majority of all its members. Five, if a member of a board in his or her personal capacity or his or her spouse, partner, close family member, business partner, or associate has a direct or indirect financial interest in any matter to be dealt with at any meeting of the board, such member A must immediately, after the interest has come to his or her attention, disclose that interest to the chairperson. B may not attend that meeting during the consideration of that matter. C may not in any manner take part as a member in the consideration of such matter by the board. Or D may not in any manner endeavor to influence the opinion or vote on any other matter of the board in connection with such matter. 6, the decision of the majority of the members of the board present at a meeting constitute a decision of the board. And in the event of equal votes, the member presiding at that meeting has a casting vote in addition to his or her deliberative vote. 7, a decision taken by the board or act performed under the authority of the board is not invalid merely by reason of an interim vacancy on the board or because a person who was not entitled to sit as a member or attend such meetings sat as such member or attended such meeting at the time when decisions was taken or the act was authorized. If the decision was taken or the act was authorized by the requisite majority of the members who were present at the time and who were entitled to sit as members of the board or attend the meeting. 8, the procedures to be followed at meetings of the board must be determined by the board. 9, the board must seize minutes to be kept of every meeting thereof. 10, the minutes referred to in subsection 9 must be kept at the office of the council. Okay, committees of the board. Number 1, subject to subsection 2, the board may from time to time appoint one or more committees that it considers appropriate for the effective functioning of the board, excluding the Compliance and Enforcement Committee, The board must A, assign members of the board to serve on committee based on their knowledge and skills. B, determine the term of reference of a committee. 2, the composition of a committee. 3, the tenure of members on a committee. 4, the reporting mechanism of a committee. And 5, the method and the reasons for the removal of a member from a committee. 3, the board may co-opt any person to a committee to support that committee in relation to his or her technical expertise, and such co-opted person does not have voting powers. 4, a person co-opted in terms of subsection 3 who is not in full-time employment of the state may be paid such remuneration or allowances as the board may determine. 5, unless specifically delegated by the board, a committee has no decision-making powers and can only make recommendations to the board. 6, a committee may meet as often as is necessary in order to carry out its functions and may determine its own procedures subject to the directions of the board. Delegation and assignment of functions by the board. Number 1, the board may A, excluding the powers and duties in relation to the Compliance and Enforcement Committee and subject to subsection 5, delegate any of its powers and assign any of its duties to any member of the board or any committee established in terms of section 12, to the Chief Executive Officer, the Chief Financial Officer, or any employee of the council. And B, amend or revoke the delegation or assignment. Number 2, notwithstanding a delegation or assignment contemplated in subsection 1, the board is not divested on the powers or relieved of the duty so delegated or assigned. 3, any delegation contemplated in subsection 1 may be made subject to such conditions as the board determine and must be communicated to the delegate or assignee in writing. Number 4, the written communication contemplated in subsection 3 must contain full particulars of the matters being delegated or assigned and of the conditions subjected to which the powers may be exercised or the duties must be performed. Five, the board may not delegate the power to make rules as contemplated in section 88, to appoint the Chief Executive Officer or the Chief Financial Officer, to decide on the strategic corporate plan of the council. 6, the board may not enter into an agreement with any person for the rendering of any specific expertise or service to assist the board in performing its function or duties. Functions of the council. 1, subject to Section 5, the council must A, establish and maintain an integrated database which is able to integrate with the database contemplated in Section 6 of the Housing Act, and which consists of 1, a register of home builders and developers, 2, a register of enrolled homes, and 3, any other register that the council consider appropriate. B, maintain and administer the funds contemplated in Section 35 or 36. C, register and deregister home builders in accordance with requirements and procedures prescribed in terms of this Act. D, enroll homes in accordance with the categories prescribed by the council. E, for the purpose of ensuring that structural integrity of a home, enter into an agreements generally or specifically with MECs regarding services to be rendered in respect of projects for the construction of homes. The acquisition of which, except in respect of any deposit that may be payable is financed solely from the proceeds of state housing subsidy. F, inspect or ensure that inspections of homes in terms of this Act in the manner prescribed by the council. G, provide training to home builders to achieve and maintain satisfactory technical standards in the home building industry. H, inform housing consumers of their rights and duties in terms of this Act and other matters relevant to the subject of this Act. I, provide information to financial institutions, conveyancers, property practitioners, social housing institutions, delivery agents as contemplated in Social Housing Act, stakeholders in the housing development projects as defined in the Housing Act, and any other interested person in order to assist them to comply with their obligations in terms of this Act. J, determine criteria for the determination of fees as envisaged in Section 40 and the differentiation between these fees based on justifiable criteria. K, advise the minister of any matter referred to the council by the minister in respect of the protection of housing consumers or the objectives of this Act. I, engage in undertakings to promote improved structural quality of homes. M, engage in undertakings to improve ethical and technical standards in the home building industry. N, prescribe the requirements for 1, the approval of the certification body, 2, the listing of a competent person, and 3, determine the minimum level of indemnity insurance required to be held by a certification body or a competent person in the circumstances contemplated in section 50.1b. The council may A, approve a certification scheme which has as its purpose the certification of performance-based method of construction as determined in the Home Builders Manual. B, approve a legal person as a certification body which is authorized to provide the certification of a design or compliance with the Home Builders Manual through its certifier. C, through board approval as contemplated in section 36 and only after consultation with the minister and the Minister of Finance, establish, maintain, and administer different funds for different purposes as contemplated in part 1 of part 1 of chapter 5. D, keep a record of competent persons. E, acquire, register, deal with, and dispose of any trademark.
Sabelo,
Yes, Chair.
can you wait? I see the hand of Honorable Powell. Honorable Powell? Is it the legal hand?
Yeah, it's not a legacy hand, Chair. I was wondering when we were going to take comments, because I need to go all the way back to section 7. I've got.
We're dealing with chapter 2. We're going to discuss chapter 2, all of it.
Afterwards. Okay. All right.
Yeah, all right.
So F, make recommendations to the minister in respect of any amendments to this act. G, ensure directives to a person or a group of persons in relation to compliance with this act. H, generally do all things necessary or expedient to achieve its objectives in terms of this act. Appointment of Chief Executive Officer and Chief Financial Officer. 1, the board must appoint a Chief Executive Officer and a Chief Financial Officer to ensure that the council meets its objectives. 2, the board must invite applications for the position of Chief Executive Officer and Chief Financial Officer by publishing advertisement in the media. 3, a person appointed as Chief Executive Officer or Chief Financial Officer must have qualifications and experience relevant to the functions of the council. Conditions of appointment of Chief Executive Officer and Chief Financial Officer. 1, the appointment of the Chief Executive Officer and the Chief Financial Officer is subject to the conclusion of an annual performance contract with the board. 2, the Chief Executive Officer and the Chief Financial Officer are appointed for a term of 5 years and may be reappointed for 1 additional term of 5 years. 3, the Chief Executive Officer and the Chief Financial Officer holds office on terms and conditions determined by the board. 4, the Chief Executive Officer and the Chief Financial Officer are entitled to a remuneration package determined by the board. 5, the Chief Executive Officer and the Chief Financial Officer are accountable to the board. Acting Executive Officer and Acting Chief Financial Officer. The board may, in writing, appoint any person who has the appropriate knowledge and skills to act as chief executive officer or chief financial officer when the holder of that office is A, in temporal unable to perform the duties connected with that office, or B, has vacated or been removed from the office and a new chief executive officer or chief financial officer, as the case may be, has not yet been appointed. 2, an acting chief executive officer or acting chief financial officer may exercise all the powers and must perform all the duties of the chief executive officer and chief financial officer, as the case may be. 3, the appointment of any acting chief executive office or acting chief financial office may not exceed a period of 6 months. Functions of chief executive officer and chief financial office. The chief executive officer is the head of the administration of the council, subject to directives issued by the board. The chief executive officer is responsible for the efficient management and administration of the affairs of the council. The function of the chief executive officer and the chief financial officer are as provided for in terms of Section 57 of the Public Finance Management Act, and as may be delegated or assigned by the council in terms of Section 56 of the Act. Delegation by Chief Executive Officer and Chief Financial Officer. The Chief Executive Officer or the Chief Financial Officer may delegate or assign any of powers and duties to a member of staff or of the council. Any delegation contemplated in subsection 1A may be made subject to such conditions as the board may determine. B, must be communicated to the delegatee or assignee in writing. And C, may be amended or withdrawn in writings by the chief executive officer or chief financial officer, as the case may be. 3, notwithstanding a delegation or assignment contemplated in the section, the chief executive officer or the chief financial officer, as the case may be, is not divested of the powers or relieved of the duties so delegated and assigned. Staff of council. The chief executive officer must A, subject to the approval of the board, determine the organogram of the council structures, and B, appoint the staff necessary to enable the council to perform its function. Access to information. The council must provide access to any of its record, subject to the provisions of the Promotion of Access to Information Act 2000, Act number 2 of 2000. Disestablishment of the National Home Builders Regulatory Council. The council may only be disestablished by an act of parliament, the council may not be declared insolvent in terms of Insolvency Act 1936, Act number 24 of 1936. Okay, Chairperson, that is chapter 2.
Thank you very much. Can we get hands to talk to chapter 2? Honorable Powell.
Thanks, Chairperson.
One. Can I note hands? Proceed.
Thanks, Chair. Paragraph 7, term of office. 7.4, when a vacancy occurs in the ranks of the members of the board appointed in terms of section 6.4, the minister must fill the vacancy for the unexpired part of the period for which his or her predecessor was appointed, etc., etc. Chair, when we talk about vacancy, or when the bill talks about vacancies that occur with respect to the chief executive officer and the chief financial officer later on, there is a minimum period in which vacancies must be filled. I would like to suggest that in terms of 7.4, that this requirement must be met within a specific period of time. We've seen, for example, at entities like the HDA, that there's just a continuous rotation of acting executives and interim board members. So I'd like to suggest that the minister must fill vacancies on the board within a specific period of time. That's recommendation 1 from my office. Then if we move to 11, paragraph 11.1, the board holds meetings at such times and places as may from time to time be determined by the board. Now, if one reads this entire section, there is no minimum number of meetings required per annum. I would like to suggest that it is not as open-ended as that the board may determine to hold meetings at such times and places as they may from time to time determine, but rather that there is a specified number of minimum number of meetings that are required, given the extensive list in terms of section 13 that the board is responsible for. So that's my second recommendation. Then if we move to section 13 or paragraph 13, delegation and assignment of functions by the board. 13.1a, the board may, A, excluding the powers and duties in relation to the Compliance and Enforcement Committee, which is the disciplinary committee from our understanding, and subject to subsection 5, the board may delegate any of its powers and assign any of its duties to any member of the board or any committee established in terms of section 12 to the chief executive officer, the chief financial officer, or any employee of the council. So basically what this says is that the board may assign or delegate any of its powers to any employee. Now, ultimately, the board needs to hold the CEO accountable. This 1A is in contradiction of the same 13.5, where it says that the board may not delegate the power A, B, C. So we need to look at the word any in 13.1a, because if we go to 5, it says that there are certain powers that the board may not delegate. So there's a contradiction that's inherent here. I also don't believe that, in terms of the necessary guidelines, King 4 and the likes, that it is wise from a fiduciary and a fiscal perspective to allow a board to delegate any of its powers, especially given the fact that the board does have statutory accountability here, and that the board is responsible for holding the CEO accountable. I don't know that that can happen where the board is delegating its own functions to a CEO. I think that we need to look at the wisdom of that. And then again, just the inherent contradiction in terms of the way that the bill is worded, the contradiction with 13.5. Then I'm going to 14. I've just reread the presentation from the Master Builders Association, and they had sounded the alarm on the definition of who and what a home builder is. So a home builder versus a developer. Now in 14 C, it says that subject to section 5, the council must register and deregister home builders in accordance with the requirements and procedures prescribed in terms of this act. I think that at this juncture, our committee needs to have quite a serious discussion on these concerns that have been raised by industry role players such as the Master Builders Association as to what defines a home builder. So if I, as Emma Powell, own a home and I hire, let's say I hire Smith Construction Company to do the renovations on my home, am I the home builder, or is Smith Construction the home builder? And I think that we really need to address this because it's been flagged by the Master Builders Association. So until we get this definition clear that's referred to in 14C, register and deregister home builders, who are they registering and who are they deregistering? The developer, Smith Construction, or Emma Powell as the person who contracts? And then in terms of 14E, it talks about for the purposes of ensuring structural integrity, the board may enter into, or the council may enter into agreements generally or specifically with MECs regarding services to be rendered in respect of projects for the construction of homes, for the acquisition of which, except in respect of any deposit that may be payable as financed solely from the proceeds of a state housing subsidy. So my understanding of this is that the council may essentially enter into agreements with regards to developments that are occurring that are financed from grants that are received from national, so HSDG, USDG, ISUPG, etc. I have a question of clarity here for the department. And that is, what about existing housing codes? So MECs, and Chairperson, you've been an MEC for a long time, you understand that you're bound by existing housing codes. Now, is this in addition to existing housing codes that MECs are bound and their contractors are bound by? Are we not creating an additional layer of bureaucracy here that MECs and their provincial administrations will have to adhere to in order to get state subsidized projects off the ground? And will that not cause unnecessary delays? We need to be rolling back red tape, not applying additional layers. Then to point 15, 15.3, a person appointed as a chief executive officer or a chief financial officer must have qualifications and experience relevant to the functions of council. I would like to suggest here, so it just says that the CEO and the CFO must have qualifications and experience that are relevant. Now, this person could have some kind of an, NQF level 3 or 4 certificate that says that they know how to build, do bricklaying. That is relevant to the functions of the council. Now, I would like to suggest that we impose in this act some form of minimum criteria in line with the public service remuneration guidelines. So if the CEO and the CFO are going to be saying earning salaries of 2.1 million rand each, that the qualifications are concomitant to the guidelines of the Public Service Commission. I don't think that we are acting with wisdom to say that the CEO or the CFO can have any qualifications relevant. We must be specific and apply minimum criteria, or insert a proviso that essentially defers to the Public Service Commission's remuneration guidelines. Sorry, Chair. Okay, those are all of my comments. Thank you, Chairperson.
Thank you very much. Honorable Dr. Kumalo.
Thanks, Chair, and best birthday wishes to you. I hope you have a beautiful day.
Thank you
even though
very
you're
much.
working. Thanks, Chair. So I just I didn't unfortunately make notes of the actual clauses, but I'll make the comments. I'm sure we will all follow. So four quick things. The requirements for reappointment of board members. I know there's a limit as to how many times they can serve, but I feel that there should be some requirements or criteria for members to be reappointed, even if it is based on their performance in the that people can just be reappointed without any guidelines. The second point I wanted to make is around the oversight of the appointment of board members, to safeguard against what we all have obviously come to know regarding appointment of board members and effectiveness of the members. I also wanted to make a submission that we have controls around the number of board meetings, like many other entities and various other levels of government. But to say it is left to their discretion, we do know the abuse that does go on, where board meetings carry on just for the sake of payment, and not so much that there is real business that could perhaps not wait, etc., etc. So I do think there should be controls there. That's a submission I'd like to make, Chair. And also relating to the CEO position, I think I'm a bit uncomfortable that the requirements are not specific, especially because we know what the functions are. So I'm not sure why we can't be explicit about what the requirements are. If we can say the requirements would be, that the person meets, the requirements of and not be specific about what those requirements are. I think I'll stop there, Chairperson. Thank you very much.
Thank you, Doctor. Honorable Seki.
Chairperson, I understand the appointments of the boards are not having a separate rule from the general rule of administration of justice. So in what Member Powell was saying, I think one or the other, there must be reference on areas like PFMA, the general standards of appointments of the board. King 2, King 3, I think they do give reference of the judiciary responsibilities of the boards. So I think we need to have an understanding of that. It's not like it's for this board of NHBRC only, but there's a stipulated rules which probably we need to take care of. I think just on what Member Powell, if I'm allowed to comment on the definition of builders, of home builders, I think if on chapter 1 it's not clear, we need to further empower that definition so that it can accommodate what she's saying. Delegated function, I want to agree with Member Powell. Delegated functions are not general, Chair. But we know that in every board there are committees or subcommittees. Normally the board will delegate those functions to those committees. So it's not general. At some point, the board will take a decision to appoint an external person for a second opinion or for a certain study. That's very specific. So I think maybe Member Powell is correct to say it can't be general. It must be stipulated according to the laws and definition of delegation. I would always want to refer to PFMA in particular and Public Services Commission. I think Public Service Commission can also assist us in that. On the payments of the board, equally, the payments of the board can be different from the standard payments of the board in the public sector or in the state affairs. So that's how I understand it. It can just be confirmed, because I don't think another board could pay 10,000 as a retainer or per meeting or per sitting, and the other one pays 20,000. They should be stipulated within the functions generally of the boards of the state. As an example, we do have boards in the entities of the department. So it should be in line with such entities. The specific, these are comments, Chair, which does need confirmation. The specific questions goes to the term of the Chief Executive Officer or Financial Officer. That says it's a 5-year term that can be extended to another 5 years, but it does not say whether that 10 years can be extended. My view, if it doesn't say, it should be saying that a chief executive officer can be appointed for 5 years, which can be extended for another 5 years only. It can't go beyond 10 years. So I would propose that insertion, that such positions cannot be held by a person for more than 10 years. Actually, if it was according to me, I was going to say 5 and 3, meaning a maximum of 8. But I don't want to spoil what is written here. If it's 5 plus 5, it should be a maximum. So we could see what, or now how do we factor in that phrase? Thank you, Chair.
Honorable Zeki, I see there is still a hand, Doctor. Is it a legacy hand? Dr. Kumalo?
Yes,
Dr.
Chair.
Kumalo?
Yes, Chair.
Yes, that you have raised the hand. Is it the legacy hand or?
It's a legacy hand, Chair. Sorry.
Okay, thank you. All right.
Apologies.
Okay. Department, as you respond, I think one of the things, delegations of responsibility does not transfer even the accountability. I think it's the most important thing that I'm not sure where does it get to be recorded, or whether it's not necessary, because sometimes people delegate and want to, they want even to delegate the responsibility. The second issue, it's on the quorum. Can we simplify it and put it 50 plus 1, so that this thing of majority, if you get Advocate Masuta, they can argue until the day comes to rise. If you just say majority, let's just simplify it and say 50 plus 1. If we just leave it as majority, legal people can argue it until the sunset, which would actually be even simplified to a person, ordinary person on the street, to understand what does it mean on the majority. Can we then get comment from the department, starting with the Mr. Masamula and or Mr. Cheney, Natasha, and then we'll finish with the state law advisor and the parliamentary legal advice, in that order.
Chair, sorry, my apologies. I got disconnected. I just need to check. I'm assuming that the issue was, and I just had a brief discussion with Mr. Masemola. Is this about the board remuneration? Would I be correct, Chair? My apologies for that, but my network's not good.
Even the function and the quorum, the number of meetings and the qualifications of this chief executive officer.
Chair, just on the, I suppose maybe I should just come in after the state law advisor, but just on the board fees issue, Chair, remember that is something that is regulated in terms of the DPSA as well as the National Treasury regulations. I think what we can do, and I suppose it's going to be an issue that we need to deal with, either in terms of the gazetting around that, and then the second one I did get was the issue around the question of the board, the appointment of the CEO and the qualifications. Chair, I'm not sure what the customary practice has been, but I suppose state law advisor can advise us and guide us on that. And I'm not quite sure if it's been practiced to include that in legislation, given it's an operational or an issue that deals with specifics. But that could be something if required, and I think it's a good point. Otherwise, it leaves it open to that. But I would assume that in relation to board qualifications, that gets, I mean, the CEO and CFO qualifications, that's something that's determined by the board in consultation with the minister. And that's how it's been traditionally done. And that is consistent with the DPSA framework, because they have a framework that also guides and determines the categorization of qualifications of CEOs and CFOs. Thanks, Chair.
Thank you. Next.
Thank you, Chairperson. I think Honorable.
Wait, Honorable Masemola. Honorable Powell, is the legacy hand or?
No, Chair, it wasn't a legacy hand. I just put my hand up while the gentleman was talking, because he was talking about the board members' fees and qualifications, and the concern had been raised not with respect to the board, but rather to the CEO and CFO, but he did address that as his last point, so I'm covered. Thank you, Chair.
Okay. Mr. Masemola, proceed.
Thanks, Chairperson. I just want to deal also with what Honorable Powell indicated, that she would wish that the feeling of vacancy must also have a minimum. I mean, the time frame, which I think is noted, and I think it's something that we can include. Yeah, I think that's what we'll deal with, but also the issue of limitations on the delegations. Indeed, it's correct that when you delegate your powers, does not exonerate you from the responsibilities. That's the tried law, that if you ask somebody to do something on your behalf, does not necessarily mean that you are not responsible for anything that comes out of the work. So I think it sometimes when you draft legislation, you don't put everything there, but I think it's something that I'm sure also we'll hear from the state law advisors as to what do they think we should include as part of, to cover what their honorable member is indicating. Thanks. Also the issue that was raised by Honorable Kumal on the issue of reappointment of board members, that it must include the performance, or rather, well, it's also part of what we indicate. Sometimes I'm sure they will also still be applying, and it will not harm if we were to say, based on the criteria to be determined by minister and the board as to how the reappointment is based on. The Honorable Tseki also requested that we must insert the word only, which I think is noted, and I'm sure it could be, as much as we thought that is clearer, but I think it's his suggestion is welcomed, and I think we can include that as to make it certain that it's only for 10 years. 5 years, if extended, it will be 10, so there will be no ambiguity on that aspect. Thanks. Natasha would then follow.
Thank you, Honorable Chair. Chairperson, there was an issue raised in relation to by Honorable Powell on the issues of a home builder, and that one needs to go and relook, into the specific definition. Chair, so when I look at what the bill says, a home builder means a person who builds or undertakes to build a home or cause a home to be built for any person, including himself or herself. So Chair, you would know with the new bill, it has taken away the provision of owner builder, which, exempts a person, from building a home for him or herself. So I'll first deal with the issue of a home builder who builds a home for a housing consumer, or a home builder who builds or undertakes or builds or undertakes or cause a home to be built for any other person. So Chair, any ordinary citizen would not necessarily have the capacity or the know-how to undertake construction or the know-how as to how to build a home. So any person, Chairperson, that builds a home must be registered, because that person would have the necessary skills and capacity to build a home. If I, as a housing consumer, want to undertake renovations or attend to renovations at my house, me being in the legal profession, Chair, I would not have the necessary skills or the know-how how to undertake, those particular construction and or renovations. And therefore, I would then appoint a home builder who has the necessary skills and expertise. Chair, and then just to give a little bit of further information, the bill as it stands maximizes the protection of housing consumers. Chair, when one look at an owner builder per se, the NHBRC does not necessarily, would not be able to ensure that particular home then complies with the necessary technical requirements. And therefore, Chair, any person that constructs or must have the necessary capacity to be able to, undertake the construction of that particular home, have the necessary skills and the know-how. Thank you, Chairperson. That was on the issue of the home builder.
State Law Advisor.
Thanks, Chair. I'll start with Member Powell's comment on 13, Chair. If we read 13A, it says the board may, excluding the powers and duties in relation to the compliance and enforcement committee, and also subject to subsection 5. So whatever the board will delegate is subject to what is said in subsection 5, the exclusion that is in subsection 5. So there is no contradiction, Chair, in reading that, because whatever is delegated under one there would be subject to what is said in subsection 5. So that part is covered there, Chair. The issue of qualifications, Chair, I think will be guided by the department if it's able to clarify the qualifications that would be required for the CEO and the COO. So if they can be clarified, there would be no problem with us formulating a provision that puts it into the legislation. But then if it can be done, maybe in terms of subordinate legislation, that would also be appropriate, Chair. With regard to the control with regard to number of meetings, I think that was Member Khumalo's comment. I'm not sure, Chair, how we can put a minimum number, Chair, to say the board must at least hold a meeting once every quarter. I can imagine us saying something like that, but I'm not sure about the maximum number, how we would be able to formulate that and still ensure that the board does all the work that it requires. It is required to do in terms of the Act. So we would require guidance on that, maybe from the board on and how many meetings that are reasonable for its functions, Chair. So. Okay. And then the Member Tseki raised the issue regarding fiduciary duties. The section already says, Chair, it adds, in fact, to what is provided for in the Public Finance Management Act. I think it's section 50, if I'm not mistaken, Chair, that talks about the fiduciary duties of the section 50 of the PFMA. That talks about the fiduciary duties of the board. So section 9 adds over and above to what is provided for in the PFMA. So 9.5, for instance, says this section must be interpreted as adding to and not deviating from the duties imposed on members of the board in terms of the Public Finance Management Act. So those duties of the board that are already in the Public Finance Management Act are added to by clause 9, Chair. And then the issue of the extension of office, I think it was dealt with by the department, and they are in agreement that they only can be added. We were also under the impression that it's clear, Chair, but I don't see any danger in adding the only to the section. The issue raised by so that was section 16.2, Chair. The issue raised by the Chair with regard to delegations, that it just doesn't transfer the responsibility. 13.2 covers that, Chair. It says, notwithstanding a delegation or assignment contemplated in subsection 1, the board is not divested of the power or relieved of the duty so delegated or assigned. So 13.2 covers your concern, Chair. The issue of quorum, in our view, is clear, Chair, but I don't foresee any danger because it would convey the same meaning in saying 50 plus 1. Thanks, Chair.
Parliament.
Thank you, Chairperson. I think all the concerns raised by members have been adequately addressed by the department and the SLA respectively. I don't want to duplicate I don't think there's anything outstanding. Safe to say that where we need to add and bolster in terms of frequency of meetings and the like, we will do so in consultation with the department and the state law advisor. But all the issues have been addressed and answered. Thank you, Chair.
There are questions in the chat, Chairperson, that the state law advisor and Parliament have to answer, Chair.
That's what I'm saying, Koliso. I'm saying Honorable Powell says the 7.4 is outstanding and 14.1 and E is outstanding and 15.3 is outstanding.
Chairperson, can I quickly come in?
Okay.
Just to clarify, so 7.4, we'd asked about specifying a minimum period of time in which the minister must fill vacancies on the board. I've been listening and I haven't heard a response on whether or not we can include a minimum time period there. My question with respect of 14E, I asked about entering into agreements with MECs, the council entering into agreement with MECs, whether or not this would nullify or what impact this would have on existing housing codes that MECs are obliged to comply with in respect of developments that are financed from the proceeds of state housing subsidies. That hasn't been responded to. And then in terms of 15.3, there was the first person who responded did touch on it, but said it's implicit, it's implied that the person appointed would have qualifications in line with the DPSA framework. We need to make that explicit. That because you could appoint a CEO on a salary of 500,000 Rand a year with an NQF level 4, like a matric. We need, in terms of this act, to ensure that the CEO and the CFO are persons of formal academic qualification relevant to the functions of the council. I'm not satisfied with the response from the department that it's implicit that this complies with the DPSA framework, because it could be on any one of the notches that are provided for in terms of the DPSA framework. My point is that we need to make sure that the act specifies minimum criteria, as do many acts. They explicitly stipulate minimum criteria. Thank you, Chairperson.
Can we get a response?
Chairperson, if I may. So
yes.
with regards to the minimum time frame, I am happy to, in consultation with the department and the state law advisor, to just close that gap up and to insert a minimum time frame in consultation with the entire legal team and the department. And I think this would just serve to bolster this bill. And then with regards to 15.3, the minimum criteria, I'm in agreement, and we note the point, and I think we can look at how we can add and how we can change this to include specific qualifications if the department and the state law advisor is in agreement to do so. And then with regards to 14.1E, perhaps the department can come in on that question. Thank you, Chairperson.
Department.
Thanks, Chairperson. I could not get that 14E question properly. Maybe my colleagues can come in and attend to it. Natasha Opito.
Can we just note it, Masemola, and then because they're not coming in, and then we'll then be, as we finalize the bill, we'll deal with it. Sabelo, you must note it. Just to
Can I
add
just
on
come in,
the,
Chair?
okay,
Okay,
that?
it's the State Law Advisor, Chair.
All right, okay, thank you.
Okay, Chair, as the bill reads, Chair, that section, all it does, the Chair, it doesn't take away from any codes that the MECs would have to adhere to. So whatever codes are there in terms of other legislation, you would still need to meet those codes, because it doesn't amend or repeal or do anything to those codes. So all it says here is the council may enter into agreements with MECs for specific services, regarding services rendered in respect of certain projects, Chair. So it doesn't take away from what is there in terms of other legislation. Thanks, Chair.
Thank you very much. On the qualification, I think we should add even experience, because formal education from the school to become a CEO which doesn't understand a public service, now it's a problem. So I think it should include the experience in terms of management. Management qualifications, experience. So that as you recraft it, it should then have that element where we include experience in terms of understanding of government operation, because some of the failure that you have, it's this thing of appointing people who are coming from who does not understand the system of government and end up messing up the processes. So I think that's one of the things that need to, as you recraft it, look into the issues of that issue of experience in management and understanding the public service itself, how it operates. Can we then proceed if there is no other hands on the matter of, I see then to Lucy Shini, I cannot pronounce that. TG?
TG will be fine, Chairperson.
Yes,
I just want to clarify. I think that the Honourable Member Powell, the concern with regards to Section 14E had to do with the additional burden over and above the existing code. So the question or the concern was, would there have to be compliance with the existing housing codes over and above the new codes? And I think that was the concern that needed to be addressed. But the Honourable Member can come in and confirm if that was the concern. Thank you so much.
Honorable Powell and Honorable Cheney, you will then respond to as Honorable Powell.
Thanks, Chair. I'll be quick. The State Law Advisor has summarized my concern. I've put some notes in the chat just because I know it's difficult for the officials to keep track of everything that's raised. My concern with 14(1)(e), and I really think that this committee needs to read this and deliberate on this more intensively, because what we're doing here, we in whether or not we approve this clause or not, we need to scrutinize existing delegations and competencies in respect of service standards agreements, because what this provision essentially does is it's creating a new authority. It's saying that on top of all of the existing codes, quantums, regulations, the provisions of the Housing Act, the decisions taken by the ministries are obliged to abide by in respect of rendering projects for the construction of homes using state subsidies, it's now saying that the council can enter into agreements regarding these services. Now, this is quite a substantive clause because we're essentially creating a new authority. We're now giving additional powers to the council that are contained in other pieces of, or that are addressed and spoken to in other pieces of legislation, and that other individuals such as the minister and various entities have in respect of existing legislation. As a nation, we are burdened by such bureaucracy and red tape as it is. And we need to look at the ordinary man in the street who's doing building, or a small startup home building company, and try and roll back red tape. And I really think that our committee needs to deliberate substantively on whether or not we agree that the council may enter into agreements with MECs when the minister already has that power and the service standards are already governed and regulated in terms of the housing code. I won't make further submissions or have an argument on this now, Chairperson, but I really do think that this clause as it stands is creating additional layers of bureaucracy and giving authority to the council that they shouldn't have at this stage. Thanks, Chair.
Thank you very much, Honorable Powell. Honorable Mr. Cheney.
Thank you, Chair. Chair, I hear what Honorable Powell was saying. I'm not sure if I'm not going to enter into a debate, but I think what we need to be able to do in relation to 14E is to understand the fact that, you see, it says for the purpose of ensuring structural integrity of a home. Now, what we need to understand is that MECs have concurrent responsibility with the minister in relation to implementation. And in each of the projects where a home is constructed, which the MEC has responsibility and accountability as executive authority for a province, it speaks about the council entering into an agreement with the MEC with regards to a home constructed within a project. You see, it says they enter into agreements generally or specifically with MECs regarding services to be rendered in respect of projects for construction of homes, the acquisition of which, except in the case of any deposit that may be payable, is financed solely from the proceeds. So what happens, and we're all aware of it, the provinces are required to ensure that every project financed with a subsidy is enrolled with the NHBRC. It also then has to ensure that the homes are enrolled. Now, it may be that the MEC might want to delegate that, because as we sit now, and I stand corrected on it, but some of the MECs have then delegated that responsibility to their accounting officers and the heads of department to enter into an agreement to ensure that every project in a province is enrolled with the NHBRC, because that's where the problem is at the moment. You are sitting with a whole range of projects that are not enrolled by provinces, so it leaves the household exposed to all of the issues that we currently find with regard to structural integrity, developers. So Chair, we can look at that and we can have a discussion. But I just wanted us to, at an operational level, understand that that's what the intention of that is. It's not about sort of including any changes or any additional levels of authority, because the fact of the matter is MECs already have that concurrent responsibility in terms of the Constitution and the Housing Act. Thanks, Chair.
Very much. Can Honorable Heron? Honorable Harold. I don't know what's happening. Honorable Harold. Your
Yes,
mic is-
Chairperson.
Oh, yes. Okay. All right. I was saying your mic is on, but we can't hear you. Now we can hear you. Proceed.
I couldn't hear you. Sorry. I wanted to just say, I don't see that. I mean, we must remember what the purpose of this bill is, which is to protect the consumer. We've all been in state subsidized housing, which from a structural perspective is often substandard. And then the consumer, the person who is the beneficiary of those homes, lives in those substandard housing, where often the houses are cracking very early, and there are problems with the construction. So for me, Section 14(1)(e) does not encroach on the housing code, which prescribes what the size of the housing must be and who qualifies. I think it's important that it does stay for the purposes of ensuring, as it says, the structural integrity of the home. So that I think the purpose, if we start with the purpose of this bill, which is to protect the consumer, in this case, the consumer is ultimately the beneficiary of a state subsidized housing product. And we need to bring an end to handing over substandard housing from a structural integrity perspective. So I think this is a really important clause to remain. Thank you.
Thank you very much, Honorable Haron. Can we then go to the next chapter? Sabelo, who can ask Kolisa to assist you.
Chair?
Yes.
I think it's Miss Shilo Shin has offered to assist with the reading of the next chapter, Chair.
Okay, all right.
Okay.
Let she proceed. Thank you. She can proceed, chapter 3.
She's no longer on the platform here.
Okay. So you can take over, Kolisa.
Can you stop sharing, Sabelo? Can you see the bill, Chair?
Yes, Kolisa, continue chapter 3.
Chapter 3, registration of home builders. Register of home builders and developers. 23, subsection 1. The council must establish and maintain a register of home builders and developers as contemplated in section 14(1)(a)(i). The purpose of the register contemplated in subsection 1 is to A, facilitate risk management in the tendering process in relation to the building of a home. B, facilitate the assessment of the performance of the home builder or a developer in the execution of home building contracts. C, provide a performance record of builders and developers. D, facilitate the regulation of the conduct of home builders and developers. E, promote minimum standards and best practice in the home building industry. F, store and provide data on the size and distribute of home builders and developers. G, reflect the volume and nature of different categories of home builders and developers. Facilitate economic and strategic research in relation to the home building industry, and I reflect any other information that the council considers necessary in relation to the purpose of this act. Contents of register 24.1. The register contemplated in section 23 must be accessible to the public and must at least reflect A, the identification particulars of home builders or a developer, B, the registration number of home builder or developer in terms of this act, and if applicable, the Companies Act or the Trust Property Control Act 1998, Act number 57 of 1998. C, the period of validity of the registration of the home builder or a developer. D, the grading category of a home builder or a developer. E, any limitation placed on the home builder or a developer. F, any penalty or sanctions imposed on the home builder or developer in terms of this act, but that penalty or sanction may not be reflected in relation to a transgression by a home builder or developer before any process contemplated in chapter V11, is it chapter 7, or any court process has been finalized, and any claim against the home warranty fund for work conducted by the home builder or a developer or their employee or agent, but or any, sorry about that, Tiloshini, I'm not sure what she wants to say, Chairperson. Can I take the call? Okay, sorry, Chairperson. She's saying she was kicked off by the network, so she's trying to rejoin. The parliamentary law advisor.
Okay, no, it's fine. Please, in the meantime, proceed as she's joining.
Okay. Any claim against the home warranty fund for work conducted by the home builder or developer or their employee. Oh, sorry, I'm now reading on 2. I was disturbed, Chair, sorry. The reflection of the status of a home builder or developer as registered on the register contemplated in section 23 is confirmation of that home builder or developer's registration. The council may, on payment of the prescribed fee, issue to a home builder or a developer a certificate of proof of registration valid for a period determined by the council. Home builder or developer to be registered. 25.1. A home builder or a developer who intends to undertake or to commission the building of a home, as the case may be, must, in the manner prescribed by the council, apply for registration as a home builder or a developer in terms of this chapter. 2, a person, developer, or an organ of state may procure the services of a home builder or a developer who is not registered in terms of a person, developer, or an organ of state may not procure the services of a home builder or a developer who is not registered in terms of this chapter. A home builder or a developer may not commence with, allow, or instruct the commencement of the building of a home if that home builder or a developer is not registered in terms of this chapter. 4, the registration of a home builder or a developer is valid for a period prescribed by the council. A home builder or a developer must, on application, a home builder or a developer must, on application, colleagues, can you please assist with the admitting of people that are joining the meeting because they are disturbing. A home builder or a developer must, on the date, or a home builder or a developer must, on application for registration, pay the registration fee determined by the council in terms of section 40. A home builder or a developer must, on the date of the anniversary of the registration of that home builder or a developer pay an annual or renewal fee prescribed by the council in terms of section 40. Requirements for registration. 26.1. The council, in consultation with the minister, must prescribe a system and the requirements for the registration of home builder and developer, which system must provide for the registration of a home builder or a developer in a grade that reflects the level of competence of that home builder or developer, and for which the criteria a fair or objectivity determinable. The determination of the level of competence referred to in subsection 1 must take into account the financial, technical, construction, and management requirements that are necessary to build a home. The council must evaluate every application for registration of home builder or a developer in accordance with the requirements prescribed by the council in terms of subsection 1 and subsection 2. Cancellation, suspension, or amendment of home builders or developers registration or grading status. 27.1. Subject to subsection 2, the council may A, cancel or suspend the registration of a home builder or developer, or amend the grading of that home builder or developer as contemplated in section 26, or B, refuse to assess or action any application for registration, including renewal of a registration of that home builder or developer. The council may only exercise the powers referred to in subsection 1 if it is satisfied or reasonable, if it is satisfied or reasonable grounds that A, the home builder or developer failed to comply with an administrative penalty, notice, or compliance notice issued in terms of section 64 or section 65 respectively, and did not, 1, make any objection to the compliance or enforcement committee as contemplated in terms of section 64.6 of section or section 65.6 against that administrative penalty, notice, or compliance notice, or 2, institute any review proceedings in terms of the Promotion of Administrative Justice Act within the prescribed time period for such objection or review, and B, the council notified the home builder or developer in writing of its intention to act in accordance with this section and did not receive any correspondence from the home builder or developer in reply to that notice. In the event of any cancellation, suspension, or amendment contemplated in this section, the council must notify the home builder or developer in writing of that cancellation, suspension, or amendment. The registration and continued registration of a home builder or a developer is subject to the Code of Conduct contemplated in section 90, subsection 2, compliance with this act, and such other conditions that the minister may prescribe. Liability of unregistered home builder or developer. Failure by a person to register, that is 28, to register or to retain the registration status as a home builder or a developer does not affect that person's liability or obligation in terms of this act. Thank you, Chair.
Thank you very much. Do we have anything on this matter? On chapter 3? I don't see any. Honorable Tseki.
Chair, this one tends to be straightforward, but my question is, if I'm a client or a, what do I call myself, a person who the home builder is building a house for?
A consumer.
A consumer. Thank you, Member Mkhoto. Wow. If I'm a consumer and this person, I'm employing this contractor to build this asset for me, how do I know that, or whose responsibility to know that this builder or this home builder is registered or not? If I would claim at some time, and then we realize that the person was not registered, would that be placed on me to say, you didn't make sure that this person is registered? Thank you, Chair.
Powell.
Thanks, Chair. On 23 2A, facilitate risk management in the tendering process in relation to building a home. What does this mean? How does the council, via the registration of a home builder / developer, facilitate the tendering process, or facilitate risk management rather? I mean, what does that look like in practice? That's, I mean, does it mean that they can interfere with the tendering process? This is open to quite wide interpretation. Then B, 23 2B, facilitate the assessment of the performance of a home builder or a developer. Facilitate the assessment. Now, I mean, is this in terms of every home that's built, every execution of every home building contract? When we talk about the council having a register so that they can facilitate the assessments of performance, I mean, I'm just thinking about things like capacity. We need details to be specified more explicitly here, because this is open to quite substantive abuse, I fear, if there are nefarious ends in respect of any specific build or project. Then 25.1, the state law advisor gave a very good example when we talked about the definition of who constitutes a home builder. And she gave the example of, as a lawyer, she wouldn't constitute a home builder, but rather the person that she contracted or she commissioned to build her home or to renovate her home would meet with the definition of a home builder. Right, but when we're talking here in terms of section 25, home builder or developer to be registered, section 25.1, the current provision states a home builder or a developer who intends to undertake or to commission the building of a home, as the case may be, must in the manner prescribed by the council apply for registration as a home builder. Now, I'm sorry, but maybe because I'm not a lawyer, I'm somewhat confused, but this provision is entirely contrary to the explanation that we were given a few minutes ago, where we were told that it's only the actual home builder, the person who lays the bricks, or the person who hires laborers to lay the bricks, that constitutes or meets with the definition of a home builder. This 25.1 says that the home builder or the developer who intends to undertake or to commission the building of a home. Now, we, as we discussed in the beginning, we need to write law that ordinary South Africans who don't have advanced education or qualifications can understand. If this bill becomes an act, and any number of people who are wanting to renovate their homes were to read this, it's absolutely not clear that this definition is the person who lays the bricks, because it specifies here 25.1, a home builder or a developer who undertakes or commissions the building of a home. Now, as the owner, I would commission the building of the home. We really need clarity on this, please, Chairperson. Yeah, if there's any further points, I'll come back to them. Thanks, Chair.
I don't see any other hands. Can we then get the response?
My hand is up, Chair.
It's not, I can't see it on the system. You can speak, Honorable Sukhoi.
Okay. Thank you, Chairperson. My question is similar to Honorable Tseki's question. On the basis of the vulnerability of our people who, when they want housing, council is one that engage home builders to build for people. And at the same time, those people are being procured by government. I'm specifically looking on the RDP houses. And our people, there is nothing that makes them to participate in that process, to know that this home builder is registered. I must take this one. A project is identified of 100 people. And this home builder, a developer, comes as procured by the municipality, is given to this group of these people. Now, how are these people going to know if this one is registered or not to protect themselves? Because there's also in the act that says the beneficiaries should know, should engage people that are registered. How is that process going to be cleaned and clarified? Thank you, Chair.
Okay, I'm trying to raise my hands now. I don't know what's the problem with my gadget. If allowed, I want to have a bite, but in the meantime, if the noise that I'm experiencing
I'm on my way.
okay.
Can we request people to mute, please? I see the lot of
I'm on my way to Parliament.
Please respect the chair. It's a birthday. Please, 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 please. Mute.
Mute.
our mics.
Hello, Chairperson.
Chair, I'm still saying I'm struggling to raise my hands. Can you recognize me?
ANC are focused. Who's speaking now? Honorable Malamatsa, you'll follow Honorable Sekhwai. Honorable Sekhwai.
Chair.
Yes, ma. Final, are you done?
Yes, I am.
Okay. Honorable Malamatsa.
Thank you, Chair. There's one aspect that I raised it earlier on. It was not given much attention. If we give that much attention, we won't. Yes. Am I audible? If not,
Yeah, no, I can see that you are in the bus.
It's not assisting, madam. Yeah, okay. I'm saying there's one aspect that we leave out, and it's the main player here. the RI is called residential inspectors. These are the people who are given right to go and check who is building where, whether it's registered or not. So it is the responsibility of the RI to know his demarcation of work and be able to identify illegal builders. Now, until you are utilizing properly and until you conduct awareness so that the consumers, they know that whatever they want to start, they must go to the RI and be given a green light, because part of the giving of the green light, it will include the checking whether the home builder is registered or not. Now, time and again, when we discuss here, we have got tendency of mixing issues. When you talk of the developers and a home builder as individuals, these are two different things. Now, the developers are those who will be wanting to develop a locality of some sort in a massive way, or even if it can be developed, but it cannot be same as just a home builder who is building a hall or building extension of a house. So every time when we discuss, we must be able to differentiate between the two, so that we don't time and again repeat what we have asked earlier on or contradict the very same bill that we want to pass, because the bill on this one was more straightforward, but we tend to go back and forward. Thank you, Chair. I just wanted to contribute on that.
Thank you, Honorable Malamata. Can we then get the department, followed by the state law advisor, and then the Parliament legal service, in that order?
Thanks, Chair. I think I was kicked out for the better part of this. I just came in when Honorable Malamaj was about to conclude. Maybe my colleagues would help. I know Natasha and Pito, they are on the platform also.
Natasha? State law advisor.
Apologies, Chairperson. I just stepped out for a minute. Can I please ask that the question be repeated?
Might be repeated if the state law advisor does not have the answer to clarify some of the issues. State law advisor.
Thanks, Chair. The first question was from Member Tseki. And the question was, if a consumer in the case of a consumer, or the question was, who is responsible to know that a person is registered? Whose responsibility is it? And I think that was in relation to consumers, Chair. According to the bill, Chair, if you look at 25(1) and 2, so you have a category there of a home builder or a developer. So if you are a home builder or a developer and you intend to undertake the building of a home yourself, or to commission the building of a home, you must in the manner prescribed by council, be registered, apply for registration. And then in the case of 25(2), Chair, it says a person, developer, or an organ of state may not procure the services of a home builder or a developer who is not registered in terms of this chapter. So basically, Chair, in terms of that, the responsibility, Chair, would be on the person who's procuring the services of a home builder to satisfy themselves that the home builder or developer is registered. So in the case of what Honorable Sihwai referred to, I would assume it's social housing that she's referring to. So in that case, it would be the the organ of state, either the department or the provincial department or local government chair, or the local authority or the municipality that is responsible for that social housing, that will, or the delivery agent that will be responsible for ensuring that a developer or a home builder that is responsible for that development is registered. So it won't be the beneficiaries that will be required to now check, because the agreement for building chair is between the department or the organ of state and the developer. So the responsibility won't be passing to the beneficiaries chair. The beneficiaries are the end recipients of the product, chairperson. And then Member Powell asked with regard to 23.2A, the reference to facilitate risk management in the tendering process. So the way I understand that provision, chair, is to say that in the system that is being developed for in terms of the bill, chair, part of its objective is to facilitate risk management, because how you do that is you've got these categories of home builders. Firstly, you need them to be registered. You need the developers to be registered. So basically, you're dealing with people or with entities that would be registered. So their skill, their level of skill is known. The level of how much claims have been associated with their work is known, because it would be in those registers, chair, that would be kept by the council. So in a way, that will, as I understand it, facilitate the issue of risk management in the tendering process. So those would be the issues that would be dealt with by this legislation in facilitating the risk management in the tendering process. And also the issue of the assessment of the performance of a home builder, because now you need to categorize the builders. That's what the legislation says. Builders, home builders will be categorized according to their skill and so on. So that will facilitate the assessment of the performance of the home builders, because you would then know from that categorization where the builder fits in the scheme of things according to those categories. So that's my understanding of those two provisions, Chairperson. Explanation of Council. 25.1. Yes, Chair.
Yes, proceed, sir.
There was a question with regard to 25.1, Chair. I'm just trying to go there. A home builder or developer who intends to undertake or to commission, I think I dealt with in trying to answer Honorable Tseki, Chair. So there's those two categories, Chair. So there would be in social housing, for instance, you would have a developer who is a municipality, who undertakes to commission the building of a home. So in that case, then it would be a different case. And then you also have the home builder who undertakes or commission the building of a home. That's a different category. And then you've got 25.2, which relates to a person, which is an individual, a person, a developer, or an organ of state. And then it says you may not procure the services of a home builder or a developer who is not registered in terms of this chapter. So there are those two categories, Chair. I hope that those two provisions show the distinction, Chair, in relation to what is intended. Thanks, Chair.
Thank you, Chairperson. It's TG. I'm covered by the State Law Advisor. Thank you.
Very much. Parliament, Legal Services.
Thank you, Chairperson. The State Law Advisor has addressed all the questions raised by the honourable members. I'm in agreement with the explanation given by the State Law Advisor. Thank you, Chairperson.
Thank you very much. With that note, can we then go to the next chapter?
Natasha said it's up, Chair.
Natasha?
Thank you,
Yes, just hold
Chairperson.
it.
Apologies, Chair. I stepped out, so I was not able to, respond at the time. However, Chair, I do, agree with what has been said by the State Law Advisor. And just to add on to that, Chair, and what Honorable Malek Macha has also indicated, in terms of the definition of a developer, it's appropriate, as it focuses on the persons in the business of housing development, Chairperson, in the circumstances, who through home builders, carry out the actual construction for purposes of sale to housing consumers and to leasing out. Chair, I also just want to mention in the current legislation, developers also, they must be registered with the NHBRC, Chairperson. Thank you, Chair.
Thank you very much. Thank you very much. With that note, can we then proceed to the next chapter?
Tiloshina, you ready?
Chairperson, my apology.
Yes, Ndatetsheki.
Chair, can we put an item that we can revisit on this residential inspector that Comrade Malimas have raised? Because I remember in all our consultations with the public, this matter was not raised, and Comrade Malemaja raised it in one of our discussions. Okay, can we note it, Chair, somewhere? Because as this matter is raised, Chair, I'm just thinking this could be discussed probably as we talk about this application and the funds, the money that needs to be paid for registering, because it links number of things. It links municipality in terms of planning, that a person can just develop a property in municipality building or in someone's building, and they'll find that that person is not registered. But I'm just saying, let's take it, Chair. We will find a way towards the end of our bill to come back to those issues. Thank you.
Thank you very much. I think those that are writing minutes, they had to, they'll capture it. Chapter 4.
Chapter 4, Enrollment. Register of Enrollments 29(1). The council must establish and maintain a register of enrollment of homes, which must be able to interface with any other register established in terms of this Act. The purpose of the register contemplated in subsection 1 is to facilitate 1, the identification of enrolled home and informing housing consumer thereof. B, a core effective procurement process in relation to building of a home. C, the inspection of enrolled home. D, the operation of the home warranty fund and the management of claims from the fund, and E, economic and strategic research in relation to home building industry. 3, the register referred to in subsection 1 must be accessible to the public and subject to Promotion of Access to Information Act 2000 must reflect the geographical location of every enrolled home. B, the home builder who enrolled the home. C, if applicable, the developer in relation to an enrolled home. D, any finalized claim against the home warranty fund that has been instituted in relation to an enrolled home, and any other information that is reasonably necessary in relation to the purpose of this act. 4, the reflection of an enrollment on the register of enrollments is proof that the home concerned is enrolled in terms of this chapter. Enrollment of home. 31, a home or developer, as the case may be, may not commence with the construction of a home unless that home is enrolled with the council in the manner and on the conditions prescribed by the council in consultation with the minister. 2, in the case where a home is part of a development, the developer consent must enroll each home within that development. 3, the council may, in terms of subsection 1, prescribe different procedure and conditions in relation to different categories of homes. 4, the council must evaluate the application for enrollment of a home in the manner prescribed by the council. 5, the council may not enroll a home unless A, the council is satisfied that the condition contemplated in subsection 1 are met, and B, the fees payable by a home builder or a developer as prescribed by the council in accordance with section 40 are paid by the home builder or developer. 6, a home builder or a developer, as the case may be, must notify the council of the date of commencement of the construction of a home. 7, when a home builder or a developer, as the case may be, has complied with the provision prescribed in terms of subsection 1, the council must update the register of enrollment indicating the enrollment status of the home concerned. 8, the council may refuse to enroll a home submitted for enrollment by a home builder or a developer if the council is satisfied that the home builder or a developer failed to comply with an administrative penalty notice or compliance notice issued in terms of section 64 or 65 as the case may be. 9, notwithstanding subsection 8, the council may not refuse to enroll a home in the case where an objection was lodged against the administrative penalty notice or compliance notice in terms of section 64(6) or 65(6) as the case may be. 10, where a home builder fails to complete the construction of a home within the time period agreed to, the housing consumer must notify the council, and the council must update the register of enrollment and the register of home builders accordingly and act in terms of chapter 7 against that home builder. 11, where a home is contemplated in subsection 10 is part of a development, the council must update the register in relation to the developer consent and act against that developer in terms of chapter 7. 12, where a housing consumer as contemplated in subsection 9 or in the case of a development, the developer consent appoints a new home builder to complete the home consent, that new home builder must notify the council of such appointment, and the council must update the register of home builder and the register of enrollments accordingly. The enrollment fee is not refundable. It is not refundable after the expiry of the warranty period. Failure to enroll home. 31.1. A home builder or a developer who failed to enroll a home in terms of Section 30 must A, immediately upon being notified by the council or otherwise becoming aware of such failure, apply for the enrollment of that home as contemplated in Section 30, and B, where construction has already commenced, immediately stop the construction until given approval by the council to proceed with such construction. 2, the council may, before giving the approval contemplated in subsection 1B, require the home builder or a developer to A, satisfy the council in the prescribed manner that the home complies with the technical requirements, and B, provide a financial guarantee to the amount prescribed by the council in relation to that home's compliance with the applicable technical standards. 3, the home builder or developer must, at the request of the council and prior to the approval of the enrollment of a home by the council, rectify any defects detected at the home builders or developers at the home builders or a developer's cost. Duties in respect of subsidy housing project 32.1. A MEC or MMC or his or her delegate may not release any funds in relation to any housing project unless the requirement of this act have been met in relation to that project. 2, the developer or organ of state in relation to a subsidy or social housing project must, in manner prescribed by the council, inform the council of the appointment of a home builder in relation to a subsidy or social housing project, and the council must update the registrar of home builders accordingly. 3, in the case where a subsidy is provided to an individual under a subsidy program, the relevant organ of state must notify the council of the approval of the application for a subsidy for that individual, and must notify that individual of his or her obligations to appoint a registered home builder who must ensure enrollment of that home in terms of this act. Failure of MEC, MMC, social housing institution or delivery agents to comply with the act, that is 33.1. Where the council becomes aware that MEC or MMC failed to comply with the provisions of this act in relation to appointing only registered home builders or ensuring that every home forming part of a subsidy housing or social housing project is enrolled, the council must, subject to subsection 2, report that failure to the minister. The council must, before reporting the failure by the MEC or MMC in terms of this section, notify that MEC or MMC of its intention to report him or her. 3, where a social housing institution or other delivery agent fails to ensure that every home that forms part of a social housing funded project is enrolled, or that only a home builder registered in terms of this act is appointed, the council must report that failure to the Social Housing Regulatory Authority established in terms of Section 7 of the Social Housing Act. Thank you, Chair.
Thank you very much. Can we see the hands that wants to speak to the issues? The chapter 4. Honorable Harold, and followed by Honorable Powell.
Thank you, Chair. Chair, I raised before when the bill was first before us, my concern around the MMC and the obligations being imposed or attempted to be imposed on the MMC. I think that this places this bill in contravention or in conflict with the Municipal Finance Management Act and the Code of Conduct for Councillors, which is a annexure to the Municipal Systems Act, An MMC cannot appoint any home builder. I mean, a council is not to be involved in the appointment of service providers. So the MMC cannot appoint a home builder, and the MMC can't withhold the payment of any to any service provider. It's the municipal manager is the accounting officer in a municipality. And I think this makes the bill ultra vires. The MMCs have very limited, they do not have executive office. You must remember that for local government, it's a council that has the legislative and administrative functions. And from a supply chain management perspective, where a home builder would be appointed or could be appointed, that is part of the administration. And the MMC cannot be involved in the administration. It's against the Systems Act, the Structures Act, and the Municipal Finance Management Act. So I did raise this before, and I'm surprised to see that it is still here. Thank you.
Thank you, Honorable Harold and Honorable Powell.
Thanks, Chair. Section 29 2B. The council must establish and maintain a register of enrollment of homes, which must be able to interface with any other register. The purpose of this register B is to facilitate the cost-effective procurement process in relation to building a home. Will this be prescriptive? Will this be suggestive? Will this be a training manual? How is the register going to facilitate cost-effective procurement processes? I mean, there are so many different private sector procurement processes that individual home builders use. I battle to understand how the register facilitates this. Then 31 1B. I'm deeply concerned. We have, as things
Throw
stand,
it up as members speak, Koliswa, so that you can see which areas.
31 1B, which speaks to the failure of a home builder or a developer to enroll a home. Now, we have to be realistic in terms of our capacity and the competency of our state and our departments and entities as things stand. Now, I'm deeply concerned about the additional layers of bureaucracy. As I've said before, that this piece of legislation, I absolutely support its overarching objective and purpose. But essentially, 31B says, or 31.1B says that where construction has already commenced, the failure to enroll a home, they must immediately stop construction until given approval by the council to proceed with construction. So I'd like to understand, what is the minimum period the council has to provide approval? What happens if we get an incompetent council, which is a possibility, as things stand, a likelihood? Now, will individual home builders have to stop construction, send their workers home if they haven't enrolled, and or let's say they have enrolled, but they haven't yet obtained approval by the council to proceed? I'm just really concerned about time periods here. Yeah, and that we're actually going to create delays in the housing supply chain with these deeply punitive and nanny state type regulations that essentially force home builders to get all sorts of planning approvals that are already legislated, but now additional enrollments in terms of this act, and that if they don't get those enrollments, they've got to down tools. But it doesn't seem to work the other way around in terms of prescribing minimum time periods in which the council has to satisfy their obligations. And then in terms of 31 2B, that the council may require the home builder to provide a financial guarantee to the amount prescribed by the council in relation to that home's compliance with applicable technical standards. Again, what type of guarantees are we talking about? A bank guarantee? I mean, how would a small scale developer that has been caught up in red tape and has been unable to enroll his home a home that he or she is building, they've got a team waiting to commence with works, they're a small scale business, and now they have to provide a financial guarantee in relation to compliance. I mean, we're looking at potentially, if we have a system that doesn't work, we're looking at potentially not only placing additional layers, requirements on small scale building firms, but also on potentially bankrupting them or rendering them unable to provide the service that their company is set up to provide because they aren't able to provide financial guarantees. So, I mean, I just need clarity in terms of what this means and what that guarantee looks like. That's all. Thanks, Chair.
Honorable Tseki. Tseki.
Chair, sorry to open this mic. It's a challenge sometimes. Chair, can we also have an understanding that when we raise an issue as a concern, we should try to provide proposals? If it's a clear question, it's different. If it's a concern, because I understand and I want to support Member Powell on the time frame that if I've enrolled, if the council have to give me a permission, it must give me maybe a permission within 5 days of enrollment so that it should be clear. Even if I could continue after 5 days, at least I've got a leg to stand on. If I could report them and all that. Unlike raising it as a concern without like making a proposal. So my view would be 5 days as a minimum. Chair, MBA in our meeting raised an issue of enrollment as an expense to both the home builder and the homeowner or the consumer. I think if that, I don't know whether our legal people or the department could have a look at that, because I don't think the intention of this bill, it should encroach on the financial aspects of those that we want to protect. But even if it does, it should be very minimal. So that issue of enrollment, can it be looked at by the department? The other issue, Chair, on the enrollment, pardon me on this one, it's not necessarily in the discussions, but one would see a development of a house like I raised earlier. You know that corner is a municipality land. And you see a person building on municipality land, now you become a whistleblower to say a municipality, someone is building a property on your land. I'm just asking whether, I remember the state law advisor said, the law has got other subordinate laws or superior laws. Legally, I've never heard of superior law. I always hear of subordinate laws, but that's a debate for another day. Would it be somehow, somewhere where there could be a note of whistleblowers in the non-enrollment of homes? Chair, pardon my English. maybe other people could put it differently. Thank you.
Thank you very much, Honorable Zeki. I don't see any other hands. Just to
My hand is up. I don't know what's happening because my icon has been up.
Ayikho. Into yakho ayibonakali lapha. Yes, chat sis.
Okay, thank you. I wish perhaps the department and the legal people could assist us. The issue of the home builder. I agree with Mamaliki about a difference between a developer and a home builder. The home builder is the person who on the ground, contracted maybe by the developer, but it may happen that home builders could stand alone. The home builders, more especially in the emerging phase that we find ourselves, for people to be developers. But where I am, Chair, is that when the home builder has not managed to finish up the house of a consumer, I see what the law is raising here, the bill. But I wish there could be something that says, firstly, the consumer be notified by a certain method. There should be a method, which is a process plan to notify consumers. And the second one is that there should be an administrative implementation process, which is going to pin down even departmental officials to make things to happen. I wish there could be something of that nature. I might not be able to present myself well in this, but it leaves, these are principles that are going to sit in a boardroom, in a cupboard, which are not known by consumers and developers and home builders are chasing times to get their money, and they are not responsible on that. So I wish there could be a process plan, which is a policy issue that would pin down these things to happen. The last one on what Honorable Aaron was raised. The minister and the MMMC are the heads of housing department. There's going to be a process of making things to be justified under them, even the MMMC. But when a contractor, a home builder, a developer is approved by the small committee of the MMMC, the MMMC has got power and an authority to approve what has been presented by the officials in a meeting of a collective committee. And the minister also has got power and authority to approve in a meeting like this, where we will be doing work all the time as the committee and the minister approves. So the issue that Aaron is raising of procurement, it's not directly that they are going to get to the committee. They are not going to go to those committees. But the process plan, the management process, which is administrative, would make them to approve those issues. Unless Aaron wants the approve, not the language that is raised here. But they have got that authority. The ladder goes to them. It's like the president. We can even say here that even the president would need to approve. It's because it has gone to the cabinet in the collective where our minister is, and then it goes to the president. President approves because the cabinet, which is the collective system of the executive, has approved. I'm trying to perhaps to come nearer on the concern by Honorable Errol in terms of the Structures Act and the minister and the other acts that do not allow. They allow them by process, plan, administrative process, and the collective system of taking decision, the decision making. I do want something that talks about consequence management in this whole issue. Perhaps let's be clarified. The issue raised by Honorable Tsege and myself about Unozolile Swai, who has not been given opportunity to know that my developer is contractors. It's contractors, and at the same time, the house is not in a good condition. I just want us to get clarity on that. We may be getting to the implementation, but I wish that the bill could have some indicators on how do we deal with that. Thank you, Chair.
Thank you very much, Honorable Sithoy. Just to
on a lighter note, Chair, Comrade Nancy says MMMC, so it's triple MC. Thank you, Chair.
Okay. Okay. No. I agree with Honorable Harold. In case we should say the municipal manager of the council, because they are responsible of awarding tenders in terms of the PFMA. By the way, this act, it says when it started, is that they repeal the previous act and they are trying to align this act to, in particular, the PFMA, which gives authority to the accounting officers to to administer resources of government, not MMCs, including the MEC. I would want us to say, because for me, this bill, it's more of administration than the political management issues. The PFMA requires the municipal manager, or bargaining MFMA requires municipal manager, and then the PFMA talks to the HOD. Those are the people who award tenders, and they must register this or enroll these houses. MEC's ministers, they play oversight. They're supposed to play oversight on the budget and not in the implementation. So, and here enrollment, the commitment of resources will be done by municipal manager and HOD. So my view is that maybe we'll get clarity from the department and the legal team that I agree with Honorable Harold in terms of the how we should structure this element of concerning the member of the Executive Council and the MMC. Thank you very much. Can we then, I see there is still hands. Is it legacy hands, honorable members? Butas, Zeki, and Honorable Harold.
Chair, I think you've covered me. I wanted to make the same point that you've just made now, that I think it should be the HOD and the municipal manager. Thank you.
Yes, okay. Can we then get the department to to respond, to talk to the issues that were raised, and then start with the department, the state law advisor, and then parliament.
Thanks, Chairperson and honorable members. I think the issue that is being raised on the section 32, subsection 1, the idea or understanding there was that MMC and MEC of human settlements, they are the ones who are carrying the responsibility of an oversight on what would be happening in their departments, and as a result, they are the ones who are the heads who must take responsibility of this kind of issues. But we note what honorable members are indicating, and I'm sure in consultation with the state law advisors and parliament legal team would resolve the issue as it's been raised. The issue that we need to put a time frame on section 31, subsection 1B, on when can the issues be clarified. I think it's something that we can also put with the understanding that some of the reasons might also be dependent on the home builder or developer to clear them up before they are resolved. But perhaps on the side of council to be able to resolve that, it could be possible to put a time frame, which obviously is dependent, as I'm saying, on the part of the builder on complying with those issues. Thanks.
So, Chair, just on the point around the question of the MEC and the MMC, Chair, I think, and I suppose we'll deal with this or discuss this with the Parliament's advisor together with the State Law advisor. The issue was around the question of accountability vis-a-vis responsibility, because you'll know that even in the PFMA, even in the MFMA, there's the whole issue of executive accountability and executive authority. The only one issue I think that we must still, which I'm not sure, because at some point there was uncertainty around this, and maybe Chair, you and those that have been in municipalities, is whether or not, if we agree that the MMC or the municipality is there in terms of an executive oversight, who is it? Because you'll know that MMCs exercise very little executive authority in terms of delegations. It's the executive mayor in certain instances that does that. And that was just the one issue around this issue, because the problem around this is that the accountability in all of our legislation rests with your executive authorities, whereas your responsibilities around is something that straddles your accounting officer and your accounting authority. Thanks, Chair.
State law advisor.
Thanks, Chair. I agree with the department chair that we would review the section 32.1 in view of the discussion that has taken place, Chair. Having regard to the powers and the powers of the MMC and the MMC and the municipal manager, Chair, in terms of the Municipal Finance Management Act. So we will do that review, Chair, and then tailor it accordingly, Chair. The question of Member Powell with regard to 29(2)B, I don't see that section or clause, Chair, as being prescriptive in how it's formulated, Chair. All it does it just records that it's meant to facilitate the identification, to facilitate a cost-effective procurement process in relation to the building of a home. So it doesn't specifically prescribe on what should happen. So basically, it would be those systems that are set up in terms of the act that will result in that, Chair. The other issues that are raised, Chair, I think it's really issues of policy that the department was placed to respond to. The issue of a time frame, we are in agreement that it can be taken care of in the legislation. But I also want to agree with the department that it will also have to be recorded that whatever time frame is provided would also be dependent to whatever compliance that the home builder or developer would need to meet. And then Member Tseki spoke about a superior law. We never referred to a superior law. We talked about other applicable laws. So there may have been a miscommunication of some sort. So we're just talking about other applicable legislation that would apply to a regulation of home building. So just to clarify that, Chair. Yeah, the other issues, Chair, really are not issues that I can deal with from a legal perspective. It's really issues of policy. Thanks, Chair.
Thank you very much. Parliament.
Thank you, Chairperson. I'm in agreement with the SLA and the department with regards to having to review section 32.1. We will get together and we'll just relook at that. With regards to the timeframes for council to revert, I'm in agreement. We can look at that and we can change it. I'm also in agreement that section 29 is not prescriptive. I don't think the purpose of section 29A is to prescribe. It is just to facilitate. And yeah, so primarily, I think the legal issues, the SLA and the department, we've agreed to look at those things. And all the legal issues have been answered in that regard. Thank you, Chairperson. Sorry, Chairperson, there's just the one issue of the section 31(2)B, the financial guarantees. Honourable Powell asked for clarity regarding that. And I'd like a moment and I'll revert to that question, Chairperson, at a later stage. Thank you.
Thank you very much. Honorable
Teki.
Zeki, I see your hands.
Chair, I was saying there was an issue raised by MBA about the cost of registration or enrollment. They made an example that if you have to enroll a wall, that can be costly to both the consumer and the home builder. So I'm not sure, it could be a policy matter, but I was saying as the department must look at that matter, because according to MBA, they are talking about exemptions that home builders or homeowner, when he wants to do certain renovations, according to them, there are certain renovations that need not to be enrolled because of the cost that will be incurred by the consumer. So I was saying that if the department can look at that, and without necessarily saying we should change those sections, but probably in the regulations and policies that could be advanced there. Chair, no, the issue of superior law, it was just in passing, advocate. It was not necessarily a question to you. Thank you, Chair.
With that note, can we then go to it's chapter 5?
Thank you, Chairperson. Chapter 5, Financial Matters, Funds and Fees. Funds of the Council. Section 34(1). The funds of the Council consist of A, any fee or any interest on a fee or any penalty on a fee which becomes due and payable in terms of this Act. Interest derived from investments. B, C, surplus to the warranty fund. D, money appropriated from Parliament, and E, any money which may accrue to the Council from any other source. 34(2), the Council must pay from its funds any money, any amount required to meet the operational cost of the Council in accordance with an annual budget for each financial year approved by the Board. 34(3), the funds referred to in subsection 1C may be applied in relation to developmental programs for the home building industry. Home Warranty Fund, Section 35(1). The Home Warranty Fund, established in terms of the Housing Consumers Protection Measures Act, continues to exist for the purpose of payment of claims submitted by a housing consumer as contemplated in Section 42, where a home builder or developer, as the case may be, fails or is unable to meet his or her obligations in terms of this Act. 35(2). The Council may, in accordance with Section 42, pay out of the Home Warranty Fund in respect of a claim contemplated in that section. Additional fund, clause 36, the Board may, subject to 14(2)(c), establish any additional fund for the purposes of achieving the objectives of the Council, including for the purpose of underwriting the Home Warranty Fund liability. Bank account, Section 37. Subject to the Public Finance Management Act, the Council must open a bank account with any bank, mutual bank, or other similar institution registered in terms of the Banks Act, 1990 Act number 94 of 1990, for the purpose of the Council's funds or any fund contemplated in this part. Management of funds, Section 38(1). The Council must take prudent measures to A, manage the risks pertaining to the Home Warranty Fund and any other fund, including its own funds as contemplated in Section 34(1), and B, to ensure that the fees and penalties payable to the Council in terms of this Act are at levels which are sufficient in aggregate to meet the financial obligations of the Council, including the Home Warranty Fund. 38(2), the Board must appoint A, A person who is authorized in terms of the Financial Advisory and Intermediary Services Act 2002, Act number 37 of 2002, and who has appropriate experience in respect of 1. Investment management and appropriate financial and risk management expertise to act as a fund manager. 2. Investment and fund administration to act as an investment fund administrator. And 3. Investment fund advice to act as an investment fund advisor in respect of a fund established in terms of this Act. And B. A committee called the Funds Advisory Committee, comprising not less than 3 and not more than 7 persons having expertise in respect of fund management or appropriate financial and risk management expertise. 3. The Chief Executive Officer and the Chief Financial Officer are ex officio members of the Funds Advisory Committee. The Funds Advisory Committee advises the Council on the prudent management of its funds and the risk pertaining to it, and makes recommendations to the Council regarding procedures and policies for the approval by the Board and implementation by the Council relating to A. Money to be paid into its funds, money to be paid out of its funds, generally and specifically for rectification costs contemplated in section 43(3). C. The administration of its funds. D. The investment of money in its funds. E. The management of the risks pertaining to its funds. And F. The lowering of the enrollment fee as contemplated in subsection 7. 5. The Funds Advisory Committee reports quarterly to the Board on the status of the Council funds and, where necessary, makes recommendations to the Board in respect of the fees and the penalties payable to the Council contemplated in subsection 1. The funds of the Council may, subject to subsection 4 and the Public Finance Management Act, be invested in accordance with policy approved by the Board. 7. The Minister may, if an actuarial assessment indicates excess free reserves in the funds of the Council, instruct the Council to lower any enrollment fee prescribed by the Council under section 40. Establishment of a non-profit company, section 39. Subject to subsection 1, subject to subsection 2 and the Public Finance Management Act, the Council may, in consultation with the Minister, establish a non-profit company. 2. The non-profit company referred to in subsection 1 may only be established A. For the purpose of utilizing the company exclusively as a mechanism for risk-based insurance offerings relative to the structural integrity of a home. B. If the Council can demonstrate that 1. There's a need for risk-based insurance offerings in accordance with business practices in order to achieve the objectives of the Council more effectively, and 2. The company will benefit the home building industry, and C. If any other conditions that may be prescribed by the Minister have been complied with. 3. The non-profit company referred to in subsection 1 is subject to the Companies Act, the Competition Act 1998, Act 89 of 1998, and any other law regulating companies or the insurance industry. Fees. 40. 1. Subject to subsections 2 and 3, the Council may determine the following fees by notice in the Gazette. A once-off registration fee to be paid by the home builder or the developer on application for registration in terms of section 25(5), which fee may be calculated in the manner prescribed by the Council. B. An annual fee to be paid by the home builder or developer as contemplated in section 25(6) for renewal of registration, which may provide for programs and projects aimed at supporting home builders and developers in relation to the acquisition of information and their development. C. An enrollment fee calculated in the manner prescribed by the Council, and D. Any other fee which the Minister authorizes by regulation. 2. The Council must, before making the determination contemplated in subsection 1, detail the criteria used to calculate the relevant fee, which criteria and proposed fees must be published in the by notice in the Gazette for comment for a period of 30 days. 3. The Council may, after evaluation of the comments received, amend the fees published in terms of subsection 2, and subject to the approval of the board, publish the final fees by notice in the Gazette. 4. The council may differentiate between different categories of enrollment fees in relation to different categories of homes and different categories of home builders and developers based on grading status. 5. The council may escalate the fees prescribed in terms of subsection 1 in accordance with this section, but if the council escalates those fees in excess of the most recent publication by Statistics South Africa of the Consumer Price Index, the council must obtain approval of the minister prior to the publication of the notice contemplated in subsection 1. Part 2, claims and recourse against home warranty fund. Commencement date and duration of warranty, section 41. 41.1. The duration of a warranty cover in relation to a structural defect occurring in a home is the period from the date of commencement of construction of a home, plus a period of 5 years after the finalization of the construction of a home, calculated as prescribed by subsection 6, 7, or 8, as the case may be. The duration of warranty cover in relation to a roof leak occurring in a home is the period commencing at the date of commencement of construction of the roof concerned, plus a period of 2 years after the finalization of the construction of a home, calculated as prescribed by subsection 6, 7, 8, as the case may be. Notwithstanding subsections 1 and 2, the minister may, by notice in the Gazette, extend the period of warranty cover. 4. Before the minister extends the period of warranty cover as contemplated in subsection 3, the council must undertake an actuarial assessment to determine whether the home warranty fund is able to provide for the additional period. 5. The enrollment fee must be proportionally adjusted in accordance with the extended period of the warranty cover as contemplated in subsection 3. 6. Subject to subsection 7, the periods of 5 and 2 years, respectively, as contemplated in subsection 1 or 2, are calculated 90 days from the date on which the final inspection of a home was conducted by an inspector appointed in terms of this Act, irrespective of whether the home has been occupied or not. 7. If the outcome of the final inspection contemplated in subsection 6 identifies an instance of non-compliance with the technical requirements, the periods contemplated in that subsection are calculated 90 days from the date on which the inspector has certified compliance with the technical requirements. 8. In the event that a final inspection referred to in subsection 6 is not performed due to an omission on the part of the council or its inspector, the commencement date of the warranty is deemed to be 90 days after the housing consumer has been granted the right of occupation, irrespective of whether or not the housing consumer occupies that home. Excuse me. Claims and limitations. 42.1. The council is not liable to pay out of the home warranty fund in respect of any claim contemplated in section 43.1 in relation to a home that is not enrolled in terms of this Act. In the case of a dispute being declared or a claim being lodged against the home warranty fund in terms of subsection 3, the home builder or the developer concerned is liable to rectify that home in accordance with any finding in terms of chapter 7 or the finding of an adjudicator as contemplated in part 3 of chapter 6. A housing consumer may institute a claim against the home warranty fund where A, there is a major structural defect or a roof leak that is attributable, my apologies, to non-compliance with the technical requirements. And B, the home builder or the developer is unable or fails to rectify a structural defect within the period prescribed by the council, or if the home builder or developer no longer exists and cannot be traced. 4, the council must reject a claim contemplated in subsection 3 in the case of that major structural defect or roof leak having caused by A, willful acts or willful omissions of the housing consumer or persons residing in the home. B, fire, explosion, or damage caused by a third party. C, lightning, storm, flood, or earthquake, or any other natural occurrence. D, inadequate maintenance or abnormal use of the home, or the imposition of any load greater than for which the structure of that home was designed, or use of the home for any purpose other than for which it was designed. E, subsidence or landslip or landslide for any cause not related to non-compliance with the technical requirements. F, pressure waves caused by aircraft or other aerial devices traveling at sonic or supersonic speeds, or the impact of aircraft or other aerial devices or articles dropped or falling therefrom. G, destruction of or damage to a home, or any loss or expense arising therefrom, or any liability of whatsoever nature related to ionizing radiations or contamination by radioactivity from whatever cause or from nuclear weapon material. H, war, invasion, act of foreign enemy, hostilities, whether declared or not, civil war, revolution, rebellion, insurrection, or military or usurped power, strike, riot, or civil commotion. I, loss or damage to any finishes unless they must be repaired or replaced due to a major structural defect in the residential structure. J, anything which is of maintenance nature, which any housing consumer could reasonably be expected to rectify himself or herself. Or K, abuse, failure to undertake reasonable maintenance or abnormal use of that home's private drainage system. 5, the home warranty fund does not cover consequential damages not related to the structure of a home, which are caused by a major structural defect. 6, a competent person or certification body must attest to the circumstances contemplated in subsection 4, except in the case of the circumstances referred to in subsection 4, B, C, and I. Claims and recourse. Section 43(1). Subject to subsection 3, the council pays out of the home warranty fund an amount for rectification of an enrolled home where a major structural defect or a roof leak has manifested itself within the relevant period contemplated in section 41 in respect of that home. 2, any payment from the home warranty fund for a major structural defect or roof leak during the construction of a home must be deducted from the amount prescribed by the minister in terms of section 44. And the balance constitutes the amount of warranty cover for the enrolled home concerned for the remainder of the warranty period. Where a home builder or developer in relation to an enrolled home is unable or fails to rectify the structural defect as contemplated in section 42, or such home builder or developer no longer exists, the council may pay out of the home warranty fund the amount determined in terms of section 44 for the rectification of the home by another home builder on the conditions contemplated in section 44. Notwithstanding subsection 3, in the case where there are reasonable grounds to believe that the cause underlying the dispute or the claim can be attributed to any action or omission by the developer or organ of state concerned, or the certification body or competent person, the council may hold that the developer or organ of state or the certification body or competent person accountable for the rectification or the cost of the rectification of that home. Excuse me. 5, the council may, subject to section 44, reduce any amount that may be expended in terms of subsections 1 or 3, or B, in exceptional circumstances prescribed by the council, instead of having a defect rectified, make payment to the housing consumer in full and final settlement of any claim. Minimum and maximum amount payable. 44. The minister may, by notice in the Gazette, determine A, the minimum and the maximum amounts which may be expended under section 43 in respect of any home due to a major structural defect or a roof leak, and B, which costs may or may not be included in the claim contemplated in section 43.
Chairperson.
Yep. Thank you very much.
It's a pleasure.
Any
Chair.
hands? Tseki.
Chair, this is one of the most important chapter for us to realize the benefits of this act. I'm also looking at the time based on your plans. Just note my points. You know, Chair, I always have my own worry when a statement says minister or whoever may decide on an increase of fees. To me, that's very general, and I'm not sure how do we protect any other person that is going to be affected by those increase. Sorry, that's one. Because if we are allowed to, there's a stipulated increase from the beginning, and for whatever reason there's another increase that is decided in the process of a standard price that I know, then obviously one or the other, there must be a consultation or an information, even if it's not going to be disputable, but there must be a way of how do we inform or consult the person that is going to be affected by that increase that comes in the process. The other, Chair, this warranty cover, the period of it. A house, let's make an example of the RDP house or a registered home builder who may take 3 years to complete a house. And then the warranty starts from the first day when that house was started to be built, but only to be finished 3 years later. It's now left with 2 years, or that 5 years will be extended. In other words, he has built this house for 5 years, whether it's an RDP or not. An example could be on those blocked houses currently, Chair. I know before the department goes to those buildings, they normally do some engineering inspections on the state of that structure. If the structure is still intact in terms of the engineering readings, then the department continues. But that house is going to be allocated to me. You know, this warranty fund on an RDP tends to be easy because that's a departmental responsibility. But on a private, it's a very difficult stage. And then on these rejections where the board may reject the payment, during our consultation, Chair, with the public spoke about the quality of material. If I can prove as a person that is raising a concern that the material that was used to build this property was not in good standard, can that also be added on the rejections, or it will be an automatic acceptance that indeed the material was substandard? And then my house must be constructed, even if it has gone beyond the 5 years of the warranty. Thank you, Chair. Noting the time, Chair.
Honorable Powell.
Thanks, Chair. I'd like to suggest on section 34 that we, in terms of 34.1, that this is subject to the necessary approvals by Treasury. Then moving on to 39.1 all the way to 3, is the establishment of a non-profit company. I need to understand how this intersects with the warranty fund, which is already essentially an insurer. It almost looks as if we're playing in the private sector space here and duplicating the purpose of the warranty fund. My understanding from reading this is that whereas the bill is intent on establishing an NPO to act as a mechanism for risk-based insurance offerings relative to the structural integrity. This is a private sector space, an insurer. There are many insurers that do this or could be contracted to do this. And then I'd like to understand how this intersects with the warranty fund, which is essentially an insurer. Then moving on, I'm trying to be quick because I'm also mindful of the time. Section 40. Section 40A, B, and C. We are now essentially creating another regulatory layer that requires additional resources from small business owners. We're similar to the PPRA. We are expecting these home builders to pay a once-off registration fee, an annual fee for programs and projects that are aimed at supporting them, despite the fact that we understand from earlier provisions in the bill that development programs are going to be funded from the surplus of the warranty fund. They must pay an annual fee that will provide programs and projects. So I don't understand why an annual fee is necessary if the intention of training and development programs or the funding that is behind these programs is supposed to come from the warranty fund surplus. Why do people need to pay an annual fee? And they must pay an enrollment fee. This is the monster state in action. I would suggest that there be no once-off registration fee and no annual fee, and that home builders merely pay enrollment fees on a project-by-project basis. Thank you, Chairperson.
Honorable Sifai.
Oh, thank you, Chair. That's 2 issues, Chair. I sometimes worried about the debate that we are having outside the structures that are mini private, and we think that they will be able to be regulated by us 100%. I don't know how could we have this debate with that council. See, because out of their practice, the practical issues that they experience, they've got their own. So that we do not speak alone. I see in the act that there's been such consultation. Now, how do we take this debate back to them so that they understand that we've made some review on how they should conduct this business? The second one, Chair, is the issue of the payment period. You see that the repayment period, when they have been penalized, remember there's also a payment period that they should we should agree upon when the house is not in a good standard. So I think unless you say those could be administrative issues, but it's important that we have that as a control measure to make them to be accountable. Thank you, Chair.
Thank you very much. Let's get a response. Start with the department and then get then the legal advisors will be the last ones.
Thanks, Chairperson and honorable members. I think the issue that has been raised that the enrollment fee may be something that it would be a burden to people who have to enroll the houses. I'm sure the section 38 subsection 7, which indicates that it can be reduced with from minister can intervene to ensure that it is indeed reduced. I'm sure Honorable Tseki will get comfort there. I think on section 34 subsection where it's requested that we should include that insert that it's subject to approval by Treasury. I think it's something that would consider with the state law advisors and parliament legal team. May just 1 minute. Well, on the issue of the increase of fees, Honorable Tseki, I think on the issues on 34 section 40 subsection 5, it is clear that the council would not necessarily on an arbitrary way just increase the fees, in that they would still have to if they increase them and they are in excess of the Statistics South Africa of the consumer price index, they will then have to get an approval from minister prior to them being publicized, where the members of the public will then have a say on whether they agree with the amounts that are being publicized. So it will not just be an arbitrary situation where even members of the public will not be informed whether there is those increments. Thanks, Chair.
Any other hand? Department? Can we give it to
thank you,
the...
Chair.
Okay.
Thank you,
Proceed,
Chair. Thank you, Chair. Good afternoon to the honorable members. I want to also deal with the other questions from Honorable Tseki. The issue of Pitso Silolo.
Okay.
Pitso Silolo from Legal Services, yes. The issue of cover that starts on commencement of construction. So according to the bill, the cover will kick in immediately upon construction until construction is concluded. Once construction is concluded, the cover will again commence from occupation, the date of occupation, and run for a period of 5 years. It doesn't mean that the period of 5 years will be counted from the date of construction or commencement of construction. And the issue of the quality material being an issue at a later stage, I think this one will be actually determined at an early stage of construction. It should not be an issue, or it should not only come up at a later stage when the cover has already lapsed, to say that the material used is a substandard material. So it should be determined at an earlier stage of construction, and it must be compliant with with the technical requirements as per the technical manual of the NHBRC. Thank you, Chair.
Thank you very much. Before the lawyers comes in, the issue of material, it's a very serious issue that I'm not even sure whether the governing legislation on the standard of the material that must needed to be used, that's help or that assists in providing a quality of homes. Because you go through these hardwares, the material that have been produced, I'm not sure who said that the standard has to be reduced. It's either the word and standard has reduced this the quality of material, both in cement, the roof, working the zinc that you have. You can name all of them, including the bricks and all those things. Maybe the department and legal team, I'm not sure whether it can be part of the regulation, or we can look at how we strengthen that, and if there is a need to lobby other portfolio committees or a department to look at the quality of the building materials that are being produced in the country, whether are they of standard, why there is a difference between the house that the zinc that I've used or my mother has used to the present zinc. Why it's the ones for now is so weak, such that any wind can take it, and when the house gets blown by the wind, those zinc they shrink like somebody has actually put it in a machine to squash them. And if you look at the zinc that were used previously, even if the roof can be removed by the wind or blown by the wind, sometimes you can still use the zinc. But recently, those zinc cannot be used again. Even if you have to remove them from the old house to the new house, you will not use them. I don't know what went wrong in that regard. So and if we were talking of building quality of houses or providing quality of houses, and not deal with the issue of material, then we are back to square one. Legal teams.
Thanks, Chair. A question from Member Tseki on the protection against the increase. I think Section 40, Chair, details the process with regard to the making of the fees, Chair, or the yes, Chair. How fees are determined. So Section 40 provides for that. So I understand Member Tseki's concern to be with regard to now 41 5. I think where it says the enrollment fee must be proportional, adjusted in accordance with the extended period of the warranty cover as contemplated in subsection 3. So I think what we would be agreeable, Chair, to then link that adjustment to section 40, Chair, just to cross-refer that it must be done in terms of the process that is there. And then with regard to Member Powell's proposal with regard to section 34.1, I didn't quite get the motivation for that proposal, Chair, because this just records where the funding of the council comes from. So in terms of what Parliament is legislating. So I don't understand why we should then make it subject to the approval of National Treasury, Chair. Because it's basically more or less a standard provision that you would find in a number of pieces of legislation that just tabulates where your sources of funding come from for that particular entity. And it never talks to the Treasury, because D, for instance, would talk about money appropriated by Parliament, where it talks about money that will come from Parliament. The other monies come from fees and interest on investments, and the surplus on the warranty fund. So it just records what the funds of council are, unless I'm missing the honourable members' comments, Chair. Those are the only two issues, Chair, that I can comment on. Thanks.
Chair.
Can we get the Parliament Legal Services, and then if there are follow-up, members will be noted for that?
Thank you, Chair. The issue of cover, I mean, that's been covered by the department. So the understanding is that the cover starts on commencement of the construction and then starts running once construction has been complete. With regards to section 40, and that talks about the fees, and section 41.5, and the agreement to link the two so that the one section speaks to the other and it's not done arbitrarily. I'm in agreement with that. We can look to redraft that. And then just insofar as I didn't get Honourable Powell's entire question, but there was a concern regarding the fact that we are looking to provide insurance when there is an insurance industry in the private sector. That is something that I think was raised by master builders in their submissions as well. And the issue of competition was also discussed. So I do think that that's something that the committee would have to come back to and discuss with regards to a way forward. Thank you, Chairperson.
Thank you very much. Can we get the Honourable Secretary? You wanted to speak, and then you'll follow by Honourable Powell and followed by Honourable Mike Masuta.
Chair, I wanted to get a process. The bill has been subjected to the housing partners that we're working with. Here we are now. We are trying to refine some of the issues. I want to be told of a process that will again involve them, so that the issues that they were not aware of, they're able to get them and engage them before the finalization of this whole bill. I wanted to get that process. How is it going to be? Because I'm concerned about the period of repayment to council by home builders when they are penalized. I wish that they should get that, they should be able to debate and engage on that even themselves. Thank you, Chair.
Thanks, Chair. It's Honourable Powell. The department's response does not address my question in regards to section 40 and the need for 3 separate fee sources, given the provisions of section 34 in terms of the existing fund sources. So in terms of section 34, we've got 5 separate sources of revenue, one of which is a fee, but we're then imposing on the industry 3 separate additional fees on top of their taxes and their rates and their building application fees. They will now, by virtue of this piece of legislation, have to pay an additional 3 sets of fees: a once-off fee, an annual fee, and an enrollment fee. My question to the department is, why are 3 fees necessary if the department envisages this council getting an appropriation from Parliament? I'd like the department to answer me on that. It's a substantive question that speaks to intention. The second, it's again in relation to section 40, but the intersection between section 40, it's going to be specific in terms of my numbering, section 41, and the intersection of section 34.3. Now, if we look at section 40B, it talks about an annual fee that will provide for programs and projects aimed at supporting home builders in the acquisition of information and their development. So these are development programs. Now it says that they must pay an annual fee so that the council can then give them development programs. Okay. But then if we look at 34.3, it says the funds referred to in subsection 1C, and that talks to the surplus of the warranty fund, may be applied in relation to developmental programs for the building industry. Now we see that the council is creating 2 separate sources of funding that will be used for the same aim, which is programs and projects. My suggestion in terms of the legislation to alleviate the financial burden that cash-strapped companies are already facing is that we reduce the number of fees that the industry must pay the council down to just an enrollment fee. And as envisaged in section 34.3, we use the surplus derived from the warranty fund. And if we look at the NHBRC's balance sheets, we see just how significant these surpluses can become. And we use rather just the surplus from the warranty fund for training and development programs. And then also just noting that the NHBRC already has a training and capacitation mandate. That is my my recommendation. Thanks, Chair.
Thank you, Honorable Masuta.
Chair, I couldn't resist going for lunch because otherwise I was going to collapse. So if it's too noisy around me, please pardon me. And if I'm not audible, I'll stand down. But the discussion around assurance or insurance between this scheme that's established in terms of this law, which is a public insurance scheme, if you like, and the existing optional private sector insurance schemes that ensure the structural failures, damage, and even absolute destruction of structures that homeowners choose to take up. It's something that I want to get a sense of, because if I choose not to be part of this entire assurance scheme provided by this law as an individual, whether as a homeowner or consumer or as a builder, and opt for a private sector do I have the right to opt out of the entire public sector scheme in order to have my entire assurance covered privately? And it may well be that the private schemes turn out to be a lot cheaper. And, you know, the whole idea of shopping around and the right to opt for something more affordable. Or is it something that's going to be imposed without discretion on the part of both constructors, and homeowners? That's the one question. The second one, and it may be based on me not having read the whole act in its full context. But the second one relates to what you have just asked, Chair, which has to do with quality of material. Now, the understanding that and the assurance that we've been given is that all other departments that have an interest in any aspect of this legislation have been consulted. I do not see much explicit cross-referencing between this act and what it seeks to regulate and what is to be regulated or is currently regulated by other laws. If you talk about quality of material, for example, it may well be that those materials are manufactured in South Africa, in which case the law governing the powers of the South African Bureau of Standards arises. It may well be that we're dealing with material that is brought into the country clandestinely, escapes SARS monitoring powers. You know, the story of illegal cigarettes, for example, that are flooding the country's economy. The issue of clothes that come from the East or textiles that come from the East that escape SARS levies and all of those things, which is all illegal. And we can talk of, we don't want to sound xenophobic, but you know of a particular community which is notorious in our communities of selling substandard foods, building materials, everything else, and where our people are exposed, where trade and industry, as far as I understand, is key, has a key role to play. I don't know if all of those things have been envisaged in the formulation of those provisions in this act. That's to create synergy with what we're trying to do and what other role players are trying to do, ultimately in order to protect our consumers. Because I know that there are hardwares out there which are selling substandard material that you're referring to, and are continuing to run business alongside those hardwares that are upholding norms and standards that are set in terms of our South African legislation. I don't know to what extent this legislation has explicitly created those synergies and didn't simply assume that the others will play the role they're supposed to play. But it's a more broader question for me, and it's triggered by the point you're raising about the quality of material, which we discussed somewhere else at some point as well. Thank you, Chair.
Thank you very much. Honorable members, it's 10 to 3. We are going to adjourn this meeting so that we'll then on Friday proceed, start where we have left it, so that some of us can have something to eat before we go into Parliament. So the department will then start by responding to your question, honorable members. Let me take this opportunity to thank all of you, including the lawyers that are here to assist us to to understand the bill better legally. So we'll reconvene on Friday to proceed, starting where we have left it, and proceed to other processes that we are required by the law rules to finalize the bill itself. Thank you very much. The meeting is adjourned.
Thank you very much, Chair.
Thank
The
you very
depart-
much, Chair. Have
the
a nice
department